rates the costs and expenses of the liquidation bankruptcy as the highest priority. Madam President, I have listed the positives because I believe this is an important piece of legislation. But there are also some very negative aspects of this bill, as my other colleagues have alluded to earlier. And I think it's important for all of us to make these remarks in order that it can reinforce the point as to the concerns that we do have. As Section 266, subsection 3 and 400 subsections 3 and 4 state that an office holder, like a liquidator or administrator, who seizes an asset not belonging to the company is not liable for any resulting loss or damage, except insofar as that loss or damage is caused by the office holder's own negligence, provided they have reasonable grounds for believing they were entitled to seize it. This provision places a high burden of proof on an innocent third party whose property is wrongly seized. Madam President, proving negligence can be difficult and costly, which may leave the third party with little practical recourse for recovering their losses. Also, because we are moving from a simpler state-centric system to a more complex, professionalized, and comprehensive legal framework, there are other negative effects that will be implemented by this bill. And I think Senator Pitts have alluded to this earlier as well, the cost factors that people who are already, companies who are already in this position will have to face, the additional cost to attract professional attorneys that could be very burdensome to people who are already going through this type of situation. This new bill introduces more sophisticated processes that will likely increase the cost of entering insolvency for individuals and companies. The current bankruptcy rules prescribes lower attorney fees with specific dollar amounts for various tasks. For example, in a summary case where assets are under $500, the total fee for a debtor's attorney is fixed at $12. It's a fixed fee. The new bill removes this fixed scale. Instead, the remuneration for insolvency practitioners, like administrators, liquidators, and trustees, will be fixed by a creditors committee of the High Court, based on principles like time spent, complexity, and risk. This shifts to a market-based hourly rate model for professional services will become more expensive for the debtor's estate. So these are very serious concerns, Madam President. Again, the simple yet effective summary administration has been replaced. The current Act has a simple summary administration in small cases for estates under $1,500, where the official receiver automatically becomes the trustee to save costs and simplify the procedure. These cases will now become much more expensive to administrate, as there is no alternative cost-saving route for them to take, as in the current laws. So, Madam President, based on these shortcomings that we've identified with this bill, again, I want to repeat that while we do support this bill, Our concerns is with the areas that are troubling and deficient, and that's why we question why the rush on this bill. Thank you, Madam President.
I recognize Senator Gabriel Zetina.
Madam President, colleagues, and those watching at home, first off, I want to say a couple words, and if I can refer to my notes. When I speak in this chamber, I try to do so not only to contribute in debates and the discussions that we are having, but I do so in a way that is educational and accessible, especially for Belizeans who tune in and genuinely try to understand the law that is being passed in their name. And so today, we're dealing with a bill, this bill, the Insolvency and Bankruptcy Bill 2025, and like many of you guys have mentioned, alluded to, that it's very much complex, long, technical, and full of legal languages. But it has real-world implications and impacts on families, workers, small businesses, business owners, entrepreneurs across this country. And so, while I do my best to scrutinize the bill carefully, I will also do my best to break it down in plain terms. So, I mention that because you'll see that a lot of it might be me referring to the bill and educating so that we can all understand what it means, not necessarily for this Senate, but for those watching at home. And yes, I do try my best to also offer concrete recommendation, because my goal is not to oppose for opposing's sake or agreeing just to agree, but to improve the law that we pass and ensure that it is fair for all Belizeans across. That being said, while the intent of the bill is commendable, and for the record, I do support this bill, and because it gives both businesses and individuals a second chance. In fact, Madam President, I did a bit of research, and this bill adopts a framework that is recognized under the UNCITRAL model law, which is gold standard for creating cross-border insolvency. But I also believe that it is my duty to scrutinize this bill in all areas where it is noble intention may unintentionally create harm or imbalance, particularly for those small business owners, workers, entrepreneurs, who, as we know, are struggling to stay afloat. Under Section 65(3), it says that the supervisor in a debt restructuring must file and distribute a copy of the final account within 60 days of the plan's end. And Section 66(2) adds that if the plan is not fully implemented, the supervisor must explain why. While it is a good start, there is no clear mechanism, at least from my observation, in this bill for creditors to challenge excessive fee, and I think that has been mentioned by several of our colleagues, nor is there any mandatory public reporting And so I asked, especially from where I'm from, the average fisherman, the tour operator, I think you guys get the point. How do we know that they aren't being taken advantage of by supervisors who charges or who may charge thousands in fee? And before I continue, Madam President, because in my contribution, I mentioned supervisors here quite a lot, and so for us to understand, as outlined in Section 64 of the bill, licensed insolvency practitioner, someone who is appointed to oversee the restructuring process when a person or business tries to settle their debts with creditors. This person becomes the bridge between debtor and their creditors. They handle money. They make payments to creditors and ensure that debtors is following the plan and report any issues to the court. In short, the supervisor is basically the guardian of the entire restructuring process. And because this particular person plays such a crucial role in determining who gets paid when and how much, we must ensure that supervisors operate with transparency and that are accessible to all Belizeans and are held to account if they misuse their power. So my recommendation, I propose that supervisors' reports be made publicly available and that any creditor be granted the right to challenge fees before the court. I believe that this would move us towards a path of fairness and, of course, in good faith. Section 35(2)(b), the bill says that supervisors must use assets to liquidate. In fact, it says discharge any sum due to potential creditors. But, Madam President, it does not define how quickly this must happen. And let us be reminded, the majority of the preferred creditors are usually workers, right? They work and then they get paid, whether bi-weekly or monthly. And workers, especially in Belize, many of them work paycheck to paycheck. And we all know how the court system in Belize works. It's a process, sometimes a lengthy process. And so I call my recommendation for a provision that requires employee wages to be paid within the first 30 days, maybe 60 days of the commencement of the liquidation. And let us add that small business suppliers to that list as well. We don't want them to suffer. This bill empowers the court to reverse transactions deemed unfair or fraudulent. That's necessary, I think. And so, but Section 237, 238, and Section 417, 418 goes as far to allow the reversal of payments to connected person within a 2-year frame, even if there is no proof of fraud. I propose that voidable transaction be reversed only where there is clear intent to defraud. Not simply because someone is related. Section 254(c)(2) allows a director to be disqualified for being, quote unquote, unfit to be concerned in the management of a company. Again, while I agree with the holding all bad actors accountable, this language, my belief, is subjective. There's always the risk that small business owners who may lack formal training but might be operating with good faith and could potentially be unjustly penalized. Again, we need to define unfit in the schedule and guarantee that transparent appeal process as provided under Section 258. Let us not punish the undertrained, only those acting in good faith, of course, where there is no misconduct. Section 283, 287, Scheduled 6 is when it talks about simplified restructuring procedure. Of course, it's an excellent initiative, again, allowing micro and small enterprises with under 1 million in sales or liabilities to restructure without full court process. But here's the thing. Where are the restructuring advisors located? Now, I say this with a sober mind, and I want you guys to keep an open mind as well, because, and I'm sure that when this was being drafted, probably you didn't consider it because Belize is such a small country anyhow. But from where I come from Burgrisky and San Pedro, and maybe there will be, you guys can enlighten me in that. I propose that a requirement for nationwide availability of restructuring advisors, like Kikaker, San Pedro, even in the south, not only be accessible maybe in Belmopan or Belize City, but nationwide. Section 294, 296 establish a registered of licensed insolvency practitioner. This is, again, I agree with it. But let us not allow that registered to exit only in the name, or to be again only in Belize City. I urge that Financial Service Commission be required to license at least one practitioner per district. I don't know if that's already in the talks. No? No? Okay, there's no regulation. Okay, but at least that be taken into account. At least one per district, right? And of course be published so that it is accessible to everyone and everyone has knowledge of the practitioner. In conclusion, Madam President, this bill has great potential. Insolvency law must be about fairness as much as it is about efficiency. Not only does this bill bring Belize in line with the global community, it also shows the international market and investors that Belize is serious about financial reform, and I welcome that. But the bill must be also about to protect not only creditors and the courts, but workers, small businesses, and honest debtors who need a second chance. So my plea is that you guys take those recommendations into account. Let us not just pass a bill that is perfect in paper, but then distance in practice. I support it. I support this bill, but we must scrutinize it. Right? So that being said, Madam President, I yield. Thank you.
I recognize Senator Christopher Cowie.
Thank you, Madam. Thank you, Madam President. from the sound of it, we have unanimous support of this bill. So maybe I don't need to make much comments in response, but I think certainly given the comments, some clarification may be warranted. But before getting into that, I want to give a little bit of background and context. This bill, this intended law, I think was set out as an objective under the first Plan Belize, if I recall correctly, along with the modernization of our companies law, along with the modernization of our securities laws. Those first two have been accomplished so far, but this has been languishing. It's been languishing because it is complex, it is dense, it is technical, it is a lot of work to pull this together. It seeks to address numerous objectives that deal with realities that don't currently exist in the current state of our law, and in a way that brings the protections that many of you here today have expressed concern about, or believe that the bill goes the opposite way. In fact, this bill, I think, is probably going to be one of the leading insolvency legislation in the CARICOM region. As Senator Pitts highlighted, it is modeled off the United Nations Commission on International Trade Law model law on insolvency. I'd like to refer to my notes in some of the comments in relation to both that UNCITRAL legislative guide as well as the World Bank principles for effective insolvency and debtor-creditor regimes. The UNCITRAL legislative guide on insolvency law indicates that important to an insolvency regime is ensuring that it is streamlined and simplified to address the needs of micro and small businesses that are knowledgeable of financial, business management, legal, and insolvency matters. The World Bank brief on insolvency and debt resolution says, efficient and predictable insolvency and debt resolution frameworks are key drivers to improve financial inclusion and increase access to credit, which may lead to the reduction of the cost for obtaining credit. Increased access to finance enhances enterprise growth, which in turn leads to preserving employment, growth, and the creation of new job opportunities. Having a good insolvency regime therefore matters, since it enhances market certainty, transparency, predictability, and good corporate governance. It also offers equitable treatment and maximizes value for the interest of all parties, debtors and creditors, and promotes and enables private sector development and growth. I highlight that, Madam President, because this bill really is done to protect, to support MSMEs, small business, to protect and enable small and large businesses alike that may run into trouble, that may end up on the brink or on the verge of insolvency, but that can be rescued. One of the senators spoke about corporate rescue. We don't have in our current law any kind of corporate rescue mechanisms or procedures to support the rescue of whether small or large business. This bill, for the first time, would provide for that. That's why when we look at the various parts, it speaks about creditors' arrangements, individual creditors' arrangements, corporate creditors' arrangements. To avoid going into bankruptcy or insolvency. These creditor arrangements, what that means essentially is an agreement amongst the creditors of a debtor, along with that debtor, for variation of different creditor liabilities of the debtor to these creditors. But by agreement, where there is no agreement, it provides for a mechanism through the courts. But what it does, it enables small and large business alike to avoid insolvency or bankruptcy. The provisions for administration, that represents another mechanism for corporate rescue, but more significantly involves the High Court. Administration, as it is defined in the law, considers the inevitability of insolvency, but provides, for example, as Senator Pitts referred to moratorium orders. Moratorium orders that are actually protections for the businesses that are in jeopardy of insolvency, because it puts a stay on claims, it puts a stay on applications for bankruptcy or liquidation. So actually moratorium orders are there to protect the business or individual at risk. So as we go through the legislation, each part of the legislation, it speaks to a different area of the insolvency regime, many of which speak to the protection and the preservation of the whether a business or the avoidance of bankruptcy of an individual. I certainly take the point of Senator Pitts that the technical competency, the technical expertise of the judiciary is a critical component of this bill. So the training of the judiciary will be a key element in the full implementation of this legislation. I think in terms of sensitization, that is something that is required across the board. And I think the Financial Services Commission fully recognizes the importance of sensitization to their cost, at their cost. But in going through that sensitization effort, it is the objective to implement this legislation in a manner that allows the use of the bill to be effective. So I believe this was shared with senators. Maybe you might not have seen it, but it was shared with the senators coming out of the meeting that we had at the Central Bank with senators. But in the documents that were shared, it lays out the proposed implementation schedule of the bill. And the implementation is expected to take actually over a year. I see 5 phases that are contemplated. Phase 1, where the foundational and immediate provisions to be implemented are parts 1, parts 12, 20, and 22. Those speak to 1, the definition section, and part 12, the netting section, part 20, the establishment of an insolvency surplus account, and part 22, the miscellaneous provisions. In that phase, the key one is the netting, really, that would involve relatively immediate implementation, expected to be effected September 2025. And that leads me to one of the other objectives of the bill. In the modernization of our bankruptcy and really we don't even have insolvency laws. In the modernization of these this regime, nonetheless, I mentioned about the protection and preservation of businesses that may be in jeopardy. That is, in a sense, one of the innovations of this legislation relative to any other legislation in the Caribbean. But at the same time, we also recognize the broader context of the conduct of business in Belize and the sectors that are of relevance in our country. So while we recognize small business, 90% of the businesses in this country are small business. They hire and employ between 60 and 70% of all workers in the country. So we have to give priority to that in the development of this legislation. But at the same time, there's also the financial services sector, the international financial services sector, that has existed for almost 3 decades, or let's call it 3 decades. It has struggled over the past decade and a half, particularly with AML compliance challenges. Now that we are where we are, where Belize is now the gold standard in terms of our AML compliance legislation, both from a technical standpoint and effectiveness in enforcement standpoint, we see the opportunity to restore and elevate the financial services sector. This netting this part on netting seeks to accomplish that in large part because the niche market that the financial services sector has and will continue to have with new provisions like this is in asset holding companies or investment holding companies. And this provision speaks to that because without it, the credit risk of companies in the event of insolvency is extremely elevated. It allows, without it, there is the reality of cherry picking of creditors. So this, in effect, is a standalone provision that supports the financial services sector. So that is why the implementation, in the phased implementation, this would be one of those that would be implemented in phase 1. Phase 2, which is not expected to be introduced until January of 2026, seeks to implement those portions that are relevant for the institutional and professional infrastructure. So that would be parts 20, 21, 17, 19, and 10. That speaks to insolvency practitioners. Now, currently in our law, we don't have any licensing of insolvency practitioners. Any standards, no standards exist for insolvency practitioners. That is clearly a problem that we have in our laws. We need qualified personnel, qualified practitioners, which would include accountants, for example, chartered accountants, attorneys, but with training beyond their immediate qualifications. It also speaks to the official receiver. This legislation heightens the significance and role of the official receiver. The official receiver already exists in law. I'm not honestly sure who the official receiver is, but what the official receiver will do under this bill is, in effect, enable the simplified debt restructuring regime for small business or MSMEs. The eligibility criteria for small business is actually already set out in the bill, and it contemplates any business that has a sales turnover of less than $1 million and liabilities of below $1 million. They become eligible for the simplified debt restructuring regime. Under that simplified debt restructuring regime, that is not insolvency. That is a small business in jeopardy of insolvency. In that scenario, they can apply to the official receiver for debt restructuring under that simplified regime. That's in effect a simplified process, not so much as going through the High Court, a simplified process in which they can seek a reprieve, staying of claims against them, and similar to the moratorium provisions. That part also provides for a restructuring advisor. In effect, what it is somebody to help the small business. So the official receiver would select someone who is a qualified person to be a restructuring advisor. Who is a qualified person? Well, it's set out in the law. It's a public accountant or a chartered accountant that will serve as that restructuring advisor. It's not complicated. And in fact, it's the official receiver that looks over, has oversight over the process in which that restructuring advisor advises and assists the small business in restructuring their business and rescuing that business for continued operation. So it obviously is a big positive, and in terms of costs, it seeks to reduce the costs associated with rescuing that business. I think one of the points raised in terms of costs on whether it's insolvency practitioners or otherwise, even office holders, which are these same persons, administrators and insolvency practitioners. Bear in mind that in the case, for example, of administration procedures, it is the debtor, it's actually the debtor, the one who owes the money, that selects the insolvency practitioner to assist them in the administration process. So it's a voluntary effort by the debtor themselves, who will, I would expect, know what the costs will be associated with the practitioner that they are recommending serve as the administrator. In the case of the third phase, which is expected to be implemented in April 2026, that focuses on the core business insolvency regimes. These include parts 2, 3, 4, 6, 5, and 6 on creditors, arrangements, administration, receivership, liquidation, and the common provisions for liquidation and bankruptcy. So that's where really the meat of the legislation gets implemented. So while all the preparatory work is being done, or would have been done, in terms of getting the sensitization done, start getting practitioners licensed, etc., it's not until April that now we have the core insolvency processes, including the rescue, corporate and individual rescue processes implemented. One point I'd like to make is in terms of receivership. Many in the profession, in the legal profession or the accounting profession, will be familiar with receiverships. Now, receiverships also have no protection, or I should say, there's very little legislation that creates guardrails in how our receivership operates, or even who serve as receivers. This legislation starts to establish those guardrails. For example, receivers right now can be a mortgagee of the assets of the debtor, or even an employee of the mortgagee of the assets of the debtor. Doesn't require any kind of standard or professional standard for acting as a receiver. This starts looking at not only establishing or creating restrictions on who can serve as receiver, but codifying the liability of that receiver, so you can't have a company anymore serve as a receiver. You have to have an individual serve as a receiver, and that individual is exposed to personal liability. So it heightens the level of responsibility that a receiver must have. In phase 4, to be implemented in July of 2026, or expected to be implemented in July of 26, is the sections on personal insolvency and debt restructuring. So whereas the phase 3 speaks to the business insolvency, phase 4 speaks to the personal insolvency, and so the parts on bankruptcy, the simplified restructuring of debts, bankruptcy offenses, and bankruptcy restriction orders are to be implemented in that phase 4. Then in phase 5, that's the last phase, the focus is on cross-border insolvency and supplementary provisions. That is to be expected to be implemented in October of 2026. That focuses in on that part on cross-border insolvency, orders in aid of foreign proceedings, malpractice, voidable transactions, and for both corporate and bankruptcy. And I would just quickly highlight in terms of voidable transactions, it is what it says. It's voidable. It's not void, and it is subject to determination by the High Court. I would think that we are in a good place when we do have the High Court to review these kinds of transactions. There are explicitly specify what the elements that would make it one or the other types of voidable transactions, whether it's an extortionate credit transaction, an unfair preference, or any other of the voidable transactions. It's before the High Court to make that determination and whether in fact it would be voided or in whole or in part, or other orders are to be made. But overall, going through the implementation schedule, it clearly reflects sensitivity to the current set of circumstances, to the need to sensitize, the need to build technical expertise on all relevant parties, and the overall value of this legislation, in fact, depends on developing that competency. So, Madam President, I just wanted to make those quick clarifications so that we can appreciate that it's not something to be feared, but to be embraced and welcomed, because it does bring our jurisdiction at that level that we find ourselves in terms of AML compliance. When we implement this insolvency law, we will have one of the most modern insolvency legislation in the world. Thank you.
Madam President, I only rise to make a clarification based on what I had presented and what Senator Courtney has said, is that...
And you're raising on a point of order?
Yes, Madam President, only to clarify that when I said phased approach, it is not to say that there is no considerations to a phased approach, but that passage of the bill should be matched with that phased approach.
Madam President, let me just start right where Senator Pitts just intervened to clarify. The objective that she has, I think, is what is intended. That is to say, the bill will be passed, and those provisions that are not yet ready for implementation will not be brought into force. You're suggesting the reverse, and that means you will have 5 pieces, 5 times you will have to come to this National Assembly to bring a piece in, another piece, another piece, another piece. Whereas sorry? No, right, so that's what I'm saying. We are doing it in a phased approach in order, and the FSC is available and will come in at the committee of the whole so that we can discuss it. Recommendations that are now being made, that are now being circulated, will now be sent to them. there will be an opportunity in the phased approach to consider them and to take on board those that are thought to be reasonable and should be embraced. I do want to stress one thing. This is a technical area. We have described the bill in varying ways: complex, dense, heavy, etc. It is modeled on UNCITRAL model law. When you seek to not tweak, but seek to change it, then you're not using the model. Senator Cetina, for example, raised the question of a director being unfit. He used the word subjective. There are dozens upon hundreds of cases that tell you what unfit means. Senator Pitts will tell you, as a practitioner, as a lawyer, when we look at something like that, we have the tools to go and search unfit director, and we will get information as to what that means. So to a person who is reading this for the first time, who is not an attorney and who is not exposed to this, you say, hold on, this looks like mischief could make. And what I'm trying to say to you is, this is not something that has been thought up in Belize for Belize. This is something that has international recognition, is recommended internationally, because there is jurisprudence, there are books, there are practices that support the way in which this is being done. I simply say that to try to give you some assurance that this is not untested, this is not something that is being created only for Belize. There has been a history of its implementation. The third point I want to make is this. This represents a significant improvement over what exists in the law today. You spoke, Senator Cetina, and I'm not picking on you, but no, the examples you gave, right, in terms of the fisherman, fisher folk, to speak in modern language. They talk about the tour guide, etc. Tour guide, fisher folk, anybody who faced difficulty as a self-employed person or an employer during COVID or at any time has no legislation that he or she can go to today and say, listen, I want protection from my creditors. I have a plan. Give me a chance to work out the difficulty that I'm in. You have no protection today. What you do today is you go down to the registry and you form an ex-company or you form an ex-business name and you left all the debts right there, and to hell with everybody. Small people, because small people buy from small people. And when you left somebody with $1,000 or $500, it means more to them. It has a more devastating impact on them than leaving somebody else with a $50,000 or $100,000 debt. Today, there's nothing that you can do. When this legislation is fully enforced, that person can go to the insolvency advisor and get advice as to how to restructure, how to access additional credit, how to prolong existing liabilities, etc. The point of the matter is this. There is a stigma that is attached to bankruptcy and insolvency. People shame for seeing their property being published for sale. People are scared to go to their bankers, their credit unions, and say, I will miss my payment for the next 2 months because X, Y, or Z. This legislation goes a long way in trying to remove that everybody in Belize, the private sector, the public sector, individuals will understand that individuals as well as businesses go through difficult periods and we must be able to work with each other. Bankruptcy is like leprosy. It was designed to put a stigma on a person so that everybody know, no deal with that person. That is not where we are in modern Belize. 2022, we passed a new company law, nearly 270 pages. And for those of us who have been practicing in what we call old 250 or 2214 components, we knew that inside out, but we jumped into the deep end with a new piece of legislation that modernized company law in Belize. So what we're saying is this is not only modern, but it attenuates and ameliorates the rigors of the financial world that we work in today. It is giving an opportunity to businesses and to individuals to rearrange their finances, to work with their creditors, to try to rescue businesses and to rescue themselves when they find themselves on hard times. And as I said at the very beginning, it also strikes the balance in giving to creditors the right to say, I worked with you for a year, and it's not working out. There is a regulated regime for how assets are taken, how assets are sold, and you raise the question of the cost of the, whether it be the liquidator. This is all regulated by the court. You can't just come in and say it's 20% and I'm going to charge you. The court has to approve the fee that that administrator or that liquidator is going to charge. So it is, as I say, a model legislation. It requires education, and I totally agree because I have the experience of clients who are being called upon by the FSC to get your books audited by a recognized person. And you say, well, where's the list of recognized people? There is none. But the FSC is still saying, get it done by a certain day or I'm going to fine you. So the FSC needs to check itself, and it needs to understand that before it implements some of these provisions, the framework and the people have to be there because they come very heavily on people operating in these spaces and insisting on compliance, but there is no ability to comply. So I would like to encourage senators, as you have all said, to support the legislation and to hold the Financial Services Commission to account in terms of the phased implementation and the education and ensuring that the practitioners in every district, or at least are available, so that they can help people to rearrange their affairs and to avoid the stigma of bankruptcy. Madam President, I ask that the question be put.
Honorable members, the question is that the bill for an act governing the insolvency of companies with mechanisms established for insolvent persons to enter into arrangements with their creditors, an administration procedure for companies, the receivership of companies and foreign companies, the liquidation of companies, foreign companies, limited partnerships and partnerships, the making of bankruptcy orders against individuals, the licensing and regulation of insolvency practitioners, the penalization and redress of wrongdoing associated with insolvent persons, the disqualification of directors, the avoidance of certain transactions, cross-border insolvency issues, netting, and the establishment of a simplified insolvency procedure for eligible companies and other matters connected therewith be read a second time. All those in favor kindly say aye. Those against kindly say no. The ayes have it.
Bill for an act governing the insolvency of companies with mechanism established for insolvent persons to enter into arrangement with their creditors and to provide for matters connected therewith or incidental thereto.
I recognize the Leader of Government Business.
Madam President, I rise to move the second reading of a bill for an act to amend the Central Bank of Belize Act, Chapter 262 of the Substantive Laws of Belize, Revised Edition 2020, to provide for the Director General of Financial Services Commission to be a member of the Board of Directors of the Central Bank of Belize and to provide for matters connected therewith or incidental thereto. Madam President, the bill is self-explanatory. It is just adding one person who the government and the central bank believe would be an appropriate person to serve on the board of the central bank, having regard to the fact that the central bank is one of the regulatory agencies in the financial services sector, as well as the Financial Services Commission. They do a lot of work together, and so the proposal is that the director of the Financial Services Commission be a member of the board.
I recognize Senator Patrick Farber.
Thank you, Madam President. Your permission to refer to my notes. Madam President, I rise with deep concern over this one. This is, I guess, where the dual support comes to an end, because really we have searched, and we really feel that this addition to the Central Bank Board doesn't make any sense. The bill proposes to place the Director General of the Financial Services Commission on the board of the Central Bank. And while this may seem as simple as Senator Courtney described, it's just an additional person on the board. This has tremendous implications for the governance and independence of the central bank and of the entire financial system, for that matter. Firstly, it is a threat to the independence of the central bank. The central bank, as we know, is the fundamental pillar of our economy. Its decisions are on monetary policy, foreign reserve, supervision, therefore must remain free from external or political influence, and with the passage of this, that won't happen. When you add the Director General of the FSC on this board, one that is close to ministerial control, one that has is a regulatory agency, and one that has close to ministerial control, we risk, Madam President, undermining the independence and sending the wrong signal to investors, financial institutions, and the Belizean public. Now, I remember listening to the House debate on this issue, and I remember the Prime Minister's response specifically. He said that, correct me if I'm wrong, Senator Koye, that there is already the Central Board Governor on the FSC board. Well, and he explained that this was a kind of reciprocal thing. Since one is already on the board of one, the other must be on the board of the other. And one bad practice doesn't make another one okay. The truth of the matter is these entities need to be independent. I sat down and tried to think of a good comparison. And I thought that maybe the Prime Minister should start to invite the opposition to cabinet meetings. Put an opposition member on the cabinet. Because when it is that one entity is starting to execute the duty that it should have, and in the case of the FSC, they have a different role, completely different role. Placing the individual in both governance structures creates a conflict of roles. If the FSC regulated institution faces a crisis, how can the Director General impartially contribute to central bank decisions? In other words, we risk delayed or compromised actions due to critical financial moments. There has been no clear explanation, that's the other thing, Madam President, as to why this amendment is necessary, other than one needs to be on the other because one was on the other. We should not be changing the governance of our most important financial institutions, Madam President, without a clear and compelling rationale. In fact, Senator Courtney, in his explanation, said nothing more than this is simple. It is to place an additional member on the central bank board. This, Madam President, we believe is a dangerous precedent. And if we start opening up the central bank's board to other regulators or political connected officials, where does it stop? We must protect against politicizing our financial governance and preserve the principle of checks and balances. And we would like to propose that there are other ways to accomplish what it is you say you seek. And I say that not from the explanation that Senator Courtney gave, because, again, his explanation was just that we are simply adding on an additional member to the board. But from the Prime Minister's explanation, you would want one entity, the Financial Services Control Committee, to know what's going on with the central bank. Well, there are other ways of doing that. For instance, can we not have joint regular committees or can there not be other ways of getting the two entities to share information, maybe through a memorandum of understanding, rather than putting members on each other's boards? We really feel, Madam Chairman, that Madam President, that when this happens, if this is to go through, the guardrails of our financial system would be weakened. And it would be a dangerous precedent. And for future generations, they will have to fix it. So we cannot support this bill, and we ask that the government withdraws it, because, again, we see no real purpose in this. Whatever else they're trying to achieve can be achieved without changing the configuration of the central bank board. Thank you, Madam President.
I recognize Senator Clifford Denison.
Glenfield, Madam President. Glenfield, Madam President.
I recognize Senator Denfield.
Glenfield Denison, Madam President. Thank you for recognition, Madam President. I had a hard time deciphering the policy behind this piece of legislation, and so I repeat from Senator Fava that this House of Enlightenment is why we're here. So I look forward to hearing the rationale for this piece of amendment before I express my support or withholding of support. But it raised a few alarm bells in my head. The first one being that there is a defined role of the central bank, and there is a defined and growing role of the Financial Services Commission, it seems. In this very House, we have passed legislation to expand the role of FSC, and now we are at the point where we are asking it to play a part in the central bank. Now, I know of formulations where bank supervision can be moved to the FSC, but I don't know why we're doing this. And so I would ask that we get an understanding of what the vision is in trying to do something like this, perhaps so that we could better assist in finding what the solution would be. Because when I looked at the legislation, I flagged a few things that are not in line with good governance. And one is that the term of office for these appointments is actually less than the term of office for the people making the appointment. So that, for example, the governor of the central bank, who is appointed for 5 years and who would have been appointed under the previous administration, his contract comes up for renewal within this term of government. And so it is always good practice to move the period of appointment so that you can avoid that sort of perception that there would not be independence. And based on, what influence people would have when they think about their reappointment, the members of the board, other than the governor, are appointed for 4 years. And the same question comes to my mind. If these people are being appointed and we're serious about the policy direction that we want the central bank to go, then I find it curious also that we have no qualification requirements for serving on the board, that we have no technical skill requirement for being on the board, save and except the ex officio posts, which are clearly rationalized. But they had a look at the composition of the board currently, and I don't know, except for Sidney Campbell, I don't know the other members of the board who are not ex officio members to have the sort of knowledge of the banking system, the regulatory framework for bank supervision, that sort of aspects. I can be corrected because I see there's a associate from Courtney Koishi may have that sort of technical background. I would like to just, maybe I'm wrong. She doesn't have it? Thanks. So that I think while we're looking at this piece of legislation, I think it's a good time to pause to reflect as to whether we could strengthen it in that way, so that if we say that we want the central bank to be focused on the things that matter, then perhaps we can have them focus on adjusting mortgage rates to help us with inflation. We can have the sort of board, the policy, giving policy directions that would affect the monetary policy to help ease some of the hard time. So I really couldn't let this go by asking if the Director General for the FSC doesn't have enough things to do. I met the gentleman, he's a very nice gentleman. I just met him a few months ago. I don't know if he's overworked and underpaid, but as the Labour Senator, I have to ask because I worry that we put so much work on the man. He's only human. And so, it's true, he's registrar of merchant ship companies registry now. Are we creating a creature that will become too big for us to do anything about? We're putting a lot of faith in the good gentleman, and I make no, cast no aspersions. Like I said, I don't know him to be anything but a consummate professional. But these questions are in my mind because if he doesn't have the support that he needs then we're setting ourselves up to fail. And when I look at the law, Madam President, there's really that gap as it relates to what we want in the people who are running our central bank. Because if I had that idea, if I could have read the law and seen what we would be, the sort of technical expertise that we would need there, I would have no difficulty supporting the rationale behind this bill, but I will await for my friend to explain before I draw my conclusions. I yield, Madam President.
I recognize Senator Zetina.
Thank you, Mr. President. I also rise to express my disagreement. The amendment to the Central Bank of Belize Act, only because there's more questions, and I think the wider public of this country would agree with me that when you have one person consolidating or having so much power is alarming. And maybe at this point, like I said, there's more questions than answer. And so at first glance, it appears very much simple. In fact, the way it was presented, it leads one to think it is simple. And adding the General of the Financial Service Commission as a member of the Central Bank Board. But we must be careful not to confuse simplicity with harmlessness, because the implication of this change is so real. Let's outline what the amendment could possibly mean. Not just, again, I said from the beginning, we're not here to oppose just for opposing sake, but let's look at it. We're putting one individual as the Director General in a position to influence both regulation of non-bank institution and monetary decision at central bank. So again, I reiterate the significance of concentration of power, and it undermines the principle check and balance between regulations. There is simply no segregation of duties, at least from where I stand. The FSC oversees hundreds of financial service providers, from credit unions to payment processors, etc., etc. So the second point is that there is probably a huge conflict of interest. And by placing the FSC Director General on the board, we're blurring the lines between regulation enforcement and national monetary policies. And again, it raises serious concerns for both, or from all angles, as far as I can see. Not only are we politicizing, or central bank becomes politicized. When you have one person, again, with so much decision making and power. And lastly, lack of transparency. So, Mr. President, yes, Mr. President, no, madam. I want strong coordination on our financial system, of course, but I do not believe, at least at this point, that this is the right way to do it. This amendment creates more questions than answers, more concentration than balance, and more risk than reassurance. And for those reasons, I respectfully cannot support this amendment. Thank you.
I recognize Senator Guerra.
Mr. President, just a few words. There is an issue as it relates to independence and influence. And I think it must be clear be made clear or highlighted that the central bank is a corporate body that by law is mandated to be independent. And it is also governed by a board of directors. It only makes good sense for the director of the Financial Services Commission, who is at the helm of the financial services market in Belize, to be able to provide a voice on the board that assists with setting monetary policy in our country. It's also worth highlighting that this Director General, by law, under the FSC Act, is appointed by the Commission, not the ministers, but the members of the Commission. So, respectfully, there are safeguards within the legislation which address the very concerns raised by the senators. That really is the extent of my contributions, Mr. President.
I recognize Senator Koi.
Thanks, Mr. President. Mr. President, it's a little difficult to comment on give a response. I'm actually taken aback, to be frank, at some of the comments that have been raised. Senator Guerra mentioned about the corporate status of the Central Bank Board. The Central Bank is a creature of statute. It has its board of directors. It has its mandate for monetary and financial stability, exchange rate stability, and taking such actions conducive to economic growth. The board is comprised of, the Central Bank Board is comprised of, I think, 3 ex officio members, the governor, the deputy governor, and the financial secretary, as well as 4 members that's appointed by the Minister of Finance. The Financial Services Commission has its 9 members. It's composed of 9 members. 4, I believe, comes from essentially the private sector, one of whom is nominated by the International Financial Services Association. And then the remaining members are the financial secretary, the governor of the central bank, the director of the FIU, the solicitor general, and the director general of the commission, who sits as ex officio. We can have discussions on a theoretical basis, and we can also have discussions on a practical basis. I think when it comes to the commission, which I had the privilege of serving on as a private sector member in the past, the contributions that were given by the governor, contributions that were given by the financial secretary and the director of financial intelligence unit have been critical to the development of the Financial Services Commission and the implementation of its mandate. I think it's similar in sense of what is contemplated here in the proposed appointment of the Director General of the Financial Services Commission onto the Central Bank Board. That is one person, that is one office out of, what is it, 7 more. The value in it is the insight that the Financial Services Commission Director General has in his role as that Director General of the Financial Services Commission that can prove to be invaluable as the overall financial sector evolves. Historically, we really didn't have much of a financial sector beyond the traditional banks and credit unions. That has all changed over the past decade to 2 decades. And it is that evolution that has driven the increasing significance of the Financial Services Commission. The Financial Services Commission evolved from the International Financial Services Commission. And that commission had the responsibility of really the offshore sector, as it then was called, whether for securities, brokerage, asset management, or just trustee services or registered agent services. It has developed over time a level of expertise in having to regulate those entities. In the meantime, the central bank has been largely focused on the regulation of banks and credit unions. The central bank still remains responsible for certain financial institutions that are non-bank entities on a domestic basis. It includes finance companies. But at the same time, the Financial Services Commission also has its responsibilities and its duties in regulating securities companies. So there is a very close connection within the financial services sector between the two regulators. And you will note that even in the DBFIA, the Domestic Banks and Financial Institutions Act, it speaks to financial holding company groups. Because as there is that evolution in the provision of financial services, we have groups, holding company groups, that are comprised of not only banks, but they're comprised of securities companies, of finance companies, of trust companies. You have the whole gamut, even insurance companies now. So much so that we have to look at that broader regulation and review and oversight of all these financial holding company groups. It is actually best practice that we have that interagency coordination. It is actually international standard that we have that interagency oversight. And the point is well taken as to the suggestion as to having a committee. But there are already committees in place, one in terms of the NAMLAC committee that looks at the anti-money laundering across the various sectors, and you have membership with the Financial Services Commission, the FIU, and the Central Bank, among others, within that committee. We also have an MOU between the Central Bank of Belize and the Financial Services Commission already in place. So there are all those different levels of cooperation. This is only an added element to that level of cooperation, having regard to the benefit and advantage that has been experienced in practice at the level of the Financial Services Commission. It is seen, it is believed that it will be an added benefit just the same if that representation is there on the board of the Central Bank. So with that, Mr. President, I just hope that that is some clarification.
I recognize the leader of government business.
Mr. President, it's disappointing when we listen to interventions which come off as if it is being made in good faith. Listen carefully. A public official is being proposed to be appointed to a board. And senators seriously stand in this Senate and talk about politicization of the Central Bank. Claude Hillock. Claude Hillock. Do you know who Claude Hillock is?
Yes, we're appointing a post. It doesn't matter who the person is.
He was the one who said he meet the man. He was the one who bring up an associate in my law firm.
She's on the board.
We are talking about politicizing the Central Bank by the appointment of one person. It is utter and complete drivel. Nonsense on stilts. Senator Dennison talks about having qualifications for members of the board of the Central Bank. Here is a proposal to appoint the Director General of the Financial Services Commission to the board. With more qualifications than that you want. What more qualifications than that you want? Central Bank Act says, as has been alluded to already, within the context of economic policy of the government, the bank shall be guided in all of its actions by the objectives of fostering monetary stability, especially as regards stability of the exchange rate, promoting credit and exchange conditions conducive to the economic growth, to the growth of the economy of Belize. Senator Farber, I don't remember the exact word you said, but words to the effect that the Central Bank is the foundation of the Belizean economy in terms of its integrity, the regulation, etc. What is the responsibility of the Financial Services Commission? Section 5 of the Financial Services Commission Act says, the function of the Commission are the following: promoting and developing Belize as a center for the carrying on of financial services, protecting and enhancing internationally the reputation of Belize as a financial center, providing within the framework of local legislation and laws appropriate supervision and regulation of the conduct of financial services, formulating appropriate policies and providing advice and assistance to the government on the regulation of financial services, preparing as the occasion demands reports and memoranda of interest to the development, protection, and regulation of Belize's financial services sector, collecting, storing, and disseminating to interested parties reliable and timely information on the growth and trends of Belize's financial services sector. Does the Director General of that institution not have some value to add to the central bank that is in law required to be monitoring, regulating the financial sector of this country? How can anyone in good faith say that the Director General of the Financial Services Commission, who has this as its statutory duty, has no value to add? I am saying again, how can it ever be suggested that the Financial Services Commission Director General has no value to add to the Central Bank Board? But what is worse, they accuse the man of conflict of interest.
Mr. President, on a point of order, Senator Ian Courtney is accusing us and saying that we said certain words when in reality we didn't. The questions that we pose are one that I believe that the wider public would pose the same questions. They're genuine questions, sir. I think at the end of the day, if we don't understand...
Yes, what's
imputing
the point of
improper
order,
motive, sir.
Senator?
Mr. President, if Senator Zatina believes that I'm imputing a proper motive, I apologize to him. That was not my intention. I repeat the question that I asked. I said, how can it seriously be said that the Director General of the Financial Services Commission has no value to add to the Central Bank Board? You didn't say that. I never say you said that. I never said nobody said that. I pose a rhetorical question and I repeat it. He said that. He said that. That he said that I see a conflict of interest. The answer is there. Yes, the answer is there. You did say that there's a conflict of interest. The long and short of it is this. The long and short of it is this. No, back off. No, you're back off. Well, who got a conflict of interest if it's not the individual? Which office? How an officer have a conflict of interest? Let's get serious. Mr. President,
Yes,
let me wind up. Let me wind up.
Leader of government business.
I say to this honorable Senate, when you look at the responsibility of the central bank, you look at the responsibility of the Financial Services Commission, there is no conflict of interest for the Director General of the Financial Services Commission to serve on the board of the central bank. It is remarkable that the governor of the central bank serves on the board of the Financial Services Commission, but there is no conflict of interest there. But in the reverse, there is a conflict of interest. I am waiting to hear the rationale as to why this proposal is to be objected to be refused. It is because the responsibility of the Financial Services Commission, as I explained to you, by law, which you should be able to read, Senator Dennison, says that its responsibility is completely aligned with the objectives of the central bank, which is to regulate the financial sector of Belize. Completely aligned. Completely aligned. To provide advice, make recommendation about legislation, assisting with the stability of the financial services sector. I want to suggest, Mr. President, that any sober reflection on this issue would lead senators to support the amendment. I think the notion that there is some mischief afoot, there is some politicization afoot, when one steps back and asks yourself, how can whoever is the Director General of the Financial Services Commission, let's forget Mr. Haylock for the moment, whoever it is, what benefit would he or she get from being on the board of a central bank other than providing whatever advice, recommendations, etc. he or she has based on his or her experience? This is not saying giving to a minister an unrestricted right to appoint another member, where you could say, all right, he obviously pull some political friend or colleague. This is an ex officio appointment. So I would urge my colleague senators and Senator Zettina, I repeat to you, if you thought I was impugning an improper motive, that was not my intention. I would urge my senators to rethink their position and to see that there is a benefit in having the Director General of the Financial Services Commission on the board of the central bank. Mr. President, I ask that the question be put.
Honorable members, the question is that the bill for an act to amend the Central Bank of Belize Act, Chapter 262 of the Substantive Laws of Belize, Revised Edition 2020, to provide for the Director General of the Financial Services Commission to be a member of the Board of Directors of the Central Bank of Belize, and to provide for matters connected therewith or incidentals thereto be read a second time. All those in favor kindly say aye. Aye. Those against kindly say no. I believe the ayes have it.
Bill for an act to amend the Central Bank of Belize Act, Chapter 262 of the Substantive Laws of Belize, Revised Edition 2020.
I recognize the Leader of Government Business.
Mr. President, I rise to move the second reading of a bill for an act to repeal and replace the Bail Reform Act, Chapter 100 of the Substantive Laws of Belize, Revised Edition 2020, to reform the bail framework in the criminal justice system and to provide for matters connected therewith or incidental thereto. Mr. President and colleague senators, this is an attempt by the government to bring, I believe it is 5 or 6 different pieces of legislation where bail is available and provisions are made for the grant or the withholding of bail into one comprehensive piece of legislation. It is an attempt by the government to give not only the guidance to persons who are applying for bail, but also the guidance to the persons who are granting bail in one piece of legislation, the criteria to be taken into account. It expands, I repeat, it expands the availability of bail to persons who are detained or arrested and makes it more available to them than it is currently on the law books. It also provides very clear provisions as to the right of appeal against decisions where bail is not granted. It makes full and complete provisions for the provision of security, forfeiture of security, recognizance, and all of that. So it is a reforming piece of legislation seeking to bring into one piece of law the whole regime for bail.
I recognize Senator Patrick Fowler.
Well, to be honest with you, get me jumping away. Because when things were good and we were agreeing with things, you had a different demeanor. And now that people dared to say otherwise, we see a different leader of government business. I know how it goes. You know, Senator Cowie got up and said exactly how he felt about what we said. I believe, with the exception of Senator Zettina. Did you speak after Senator Zettina? Before. So he's the only one you may not have had the benefit of commenting on, but I appreciate that he accepted that the memorandum of understanding and the joint committees and so on was a way to go. He never just attack. but it's a different approach I see, and the tag team that you do is wonderful. I think the pity is that you don't get to have Senator Koyi last to kind of smoothen the ruffled feathers afterwards, but fair enough. I think the first thing we want to say about this bill is that it does make an attempt to modernize, as you've pointed out, Senator Courtney, and it does as well try to bring together other pieces of legislation that are outdated and that have a greater number of legislation in terms of the laws. So we now have one piece of legislation that we're aiming to achieve, where all that 6 pieces of legislation previously attempted to achieve could be achieved. So when you first glance at the bill, it seems wonderful. However, the deeper and deeper you go in terms of the examination, it becomes evident that while some of these provisions are indeed commendable, many of its elements pose severe threats to fundamental rights and disproportionately affect the poor and the marginalized. This is a point that we've made in the House of Representatives, and we intend to share again today. But before I get into the negatives, let me go on with some of the things that we found pleasing in the bill. And should I say, Senator Courtney, that it is a bill that we could potentially support with the right amendments? But let me begin with the commendable parts of the bill, and I will reference a section so that you know where I'm coming from. Firstly, it allows for clarity and consolidation, as I've mentioned. 6 bills, and as you've mentioned, 6 bills or 6 acts of law that now come into one. And this is addressed in section 1 to 3 of the bill. The second point is that it's good because it protects victims and the public. And we see that especially in section 6.2, which requires decision makers to consider public safety, community ties, and whether releasing the defendant would undermine the public peace. If these things are a problem, then it's addressed in this bill. There is as well the modernizing and the use of electronic tools, particularly the electronic monitoring tool, something that we've long seen in the movies, but we've not enjoyed here in Belize. We see where section 7.3c allows for this, allows for things like curfew, so you actually get to go out, but after a certain hour you have to be in. We see another positive in that there are suggested regular reviews and appeals in section 9 and 11, so that there can be modern and up-to-date reviews. But our critical concerns, Mr. President, are as follows. Under section 5.2 of the bill and schedule 1, we see a wide array of offenses, including not just violent crimes, but also immigration infractions. In schedule 1, item 12, we see about immigration infractions, and we also see certain traffic offenses in items 14 and 15, and firearm offenses in item 9. All of this requires bail to be granted solely by a judge, and that is limiting bail access to judges only, and that could be a potential problem, especially, Mr. President, in rural areas where judges are not regularly present, so that these accused persons would have to spend extended periods in detention without having bail consideration. A second concern we have, Mr. President, is the dangerous expansion of police bail discretion. highlighted in section 5.2a, Roman numeral 2. This section allows for commissioned officers to decide on bail for offenses punishable upon summary conviction. And the problem with this, Mr. President, is that police officers are not always impartial adjudicators. We entrust them with such discretion, and that could potentially cause a problem because their discretion risks arbitrary denial, particularly in marginalized community where very small people know each other. Police may have some kind of vendetta against the person in a community or a family against a family in the community. And there might be strained police relationships that could affect this. A third issue is the excessive penalties for absconding. This is referred to in section 12. And this one, I've seen this happen, in fact, where the reason why you don't appear once you get bail could be something very simple. You're not there when they call your name at the front of the court, and they believe that you're absent, and maybe something has kept you for a little while, and because you weren't there, they put out a bench warrant for you right away. But there could be legitimate reasons, including transportation, including weather. We have seen where people can't come out of their house because their house flooded, their yard flooded, or especially if you live on the London bridges in some areas of the city and so on, but you can't get the court for 9 o'clock. That has, under this bill, serious penalties. And so we feel that this is a problem because it is excessive and it's unjust, and it needs to carry a lighter penalty in our view. Fourthly, there is the restrictive surety and recognition provision, section 14 and 15 and schedule 4. Sections 14 and 15, reinforced by schedule 4, set strict requirements on who can serve as a surety. The exempt list stated in schedule 4 part 1 excludes community leaders, religious ministers and teachers, some of the very people who are trusted and willing to support young defendants. You go to the people who you know, but yet these people are being excluded. And the truth of the matter is, sometimes people are very unwilling to offer a surety on your behalf. That a pastor, Senator Timbrell, who would take that risk on you, or a community leader would take that risk on you, or a teacher who knew you well would take that risk on you. But people, regular people, probably not. And what this bill does is exclude those people who would take the risk on you. Section 19 prohibits the use of the same property as security for more than one recognizance without court permission, adding further hurdles for the poor. I guess they don't want you to get into the business of offering a surety or offering your property as surety. But that could be a hindrance as well. And I suppose the aim of this bill is to make sure that bail works, but that it is as easy as possible, that it works for those who need it and not against those persons, while, of course, safeguarding things, because you don't want things to just be reckless either. And then there is this one that I tread lightly on, Senator Courtney, because it speaks about ministerial overreach and amendments, section 21. Section 21 allows the minister to amend penalties and schedules via regulation, subject only to negative or affirmative resolutions. You know, I remember when Plan Belize was first brought to the table after the election, there was an extremely dedicated section of the first House meeting to the good governance motion. That's what it was indeed, and then gone through details. And one of the big ticket items in that motion, which came basically from the manifesto of the People's United Party for that election year, which they have now uploaded as 2.0. One of the big ticket items was that they would decrease ministerial powers in legislation. We'll all remember it who were around. And then when they started enjoying the ministerial niceties, and you realize that sometimes there are moves afoot to handicap you, so as the minister, you have to do a certain thing. But when the shoe is on the other foot, no, we have to limit ministerial powers. But here you have it in full effect. Increase ministerial powers. It undermines the parliamentary oversight on matters affecting constitutional rights and liberties as well when this is allowed. And I suspect this is it comes in the form of what an SI that they sign and just... All right. But it says it's subjected to negative or affirmative, but I'll wait. And then there is the issue of socio-economic inequality as well. These provisions amount to what I call a criminalization of poverty, because without money and without connections, no sureties can be secured. You have to have the right resources and things that we consider to be just regular run-of-the-mill, like getting a taxi to go to court, or go from one jurisdiction to another one to go to court, because whatever offense they charge you with is in another area. I was once charged with an offense in Belmopan and had to come to court in Belmopan, even though I lived in Belize City. But they will argue that I could have paid my way. But for a young person on the south side of Belize City, for instance, getting a ride to Belmopan or to Cairo or to Punta Gorda to attend court or wherever it is they have to attend court, it's pretty expensive and it is a hindrance. So, in true spirit to what I've maintained all day, Mr. President, I'd like to make some recommendations for this bill to be better. We propose, Mr. President, to amend Section 5.2 and Schedule 1 to allow for magistrates to grant bail in a wider range of offenses, especially for non-violent and first-time offenders. We propose to reduce the penalties in Section 12 for failure to appear, incorporating a tiered approach, for example, fines or community service for first offenses. We propose a revision of Section 14 and 15 and Schedule 4 to allow a broader set of trusted individuals to act as sureties, including pastors, principals, teachers, and community leaders. We propose to remove or restrict the powers in Section 21, requiring parliamentary approval for any substantive amendments affecting the rights of our citizens. Mr. President, we must remember that bail is not punishment. It is a constitutional safeguard to protect the presumption of innocence while ensuring appearance at the trial. This bill, as currently drafted, risks turning our justice system into one where freedom before trial is a privilege reserved for the wealthy and the connected. And I call on this honorable chamber to correct these flaws, to protect the rights of all Belizeans, and to ensure that justice is not only done, but seen to be done equally and fairly. Before I sit down, Mr. President, again I am trying to familiarize myself with the workings of the Senate versus the House, where I spent a very long time. But I am not sure what just occurred. The lead government senator promised us an opportunity to get our recommendations heard and promised us that the FSC people were here. Well, we never reached out. But so we did you presented for it to be read without any amendments a second time?
Sure. No. No. When we go into committee, we will hear them. If there are any amendments, then we'll report it back with or without amendments.
Okay.
So we haven't reached this.
All right. Thank you for the clarification and pardon my sometimes being the operative word. I'll take it. But yes, with that correction, then I am more confident to place forward these recommendations that we have in the hope that it can be a contribution to making the bill a better bill, and of course the laws that we are genuinely trying to improve, better legislation for our country. Thank you, Mr. President.
I recognize Senator Galvez.
Thank you, Mr. President. I rise today to express my full support for the Bill 2025, a bill that is not only timely, but necessary to ensure that our justice system is fair, transparent, and responsive to the needs of all Belizeans. If you would allow me, I'd like to refer to my notes. This bill seeks to replace the outdated Bail Reform Act with a modern legal framework that is clear, comprehensive, and rights-based. At its core, it reaffirms that a person is innocent until proven guilty, and that the right to bail should not be determined by income or social status. It strengthens the presumption of bail, while simultaneously accounting for the risk of flight, risk to public safety, and the potential for obstruction of justice. But, Mr. President, in my support of this bill, let me also address the concern raised by the opposition, specifically the leader of the opposition at the last House sitting, specifically her suggestion that this bill lacks consideration for the poor and marginalized, that we also heard echoed in here today. This is a serious claim, one that I respectfully but strongly dispute. The leader of the opposition raised concerns about high bail amounts and stringent requirements that she suggested would cut off the poor from accessing justice. However, Section 14.1 of the bill could not be clearer. No defendant shall be required to give excessive bail. This protects economically vulnerable individuals from being unfairly held simply because they cannot afford high cash bail or expensive sureties. Additionally, Section 10.3 mandates that judges and magistrates are to conduct a bi-weekly review of the cases involving persons who have been granted bail but remain in custody. This guarantees that persons who lack the necessary resources to meet the conditions of bail are not left to languish behind bars simply because they cannot afford it. Likewise, under this bill, both defendants and the prosecution are allowed to appeal bail decisions, reinforcing fairness and legal checks and balances. Section 8(2)-3 also allows defendants to ask for changes to their bail conditions if the situation changes, and also allows them to reapply for bail if new evidence comes up. This gives vulnerable persons more chances to be released on their own recognizance. This, Mr. President, is fairness at its core. Still, I also heard concerns from the leader of the opposition about the accountability of police officers serving as deciding officials on bail. If, for the sake of this argument, a police officer denies bail unfairly or sets conditions that are unreasonable, this would not only be legally challengeable, but would be in breach of this very law. Because as I mentioned before, this bill clearly states that 1, all defendants are presumed entitled to bail unless disqualified by specific criteria outlined in this bill, and 2, that bail must be considered within 48 hours of arrest. meaning that bail should not and cannot be denied if a person is entitled to it. And if we are to read Section 9 of this bill, it also helps to enhance transparency and protects against bias, as it mandates that all bail decisions must be recorded with reasons. This makes it easier and more accessible for persons to challenge unfair or discriminatory decisions, particularly those biased against underprivileged or marginalized defendants. And I think it's very sad that the opposition has put forth this notion that they cannot trust police officers to use their discretion and exercise their duties with fairness. Those who have been entrusted to enforce our laws, we should be able to put our trust in them to exercise their duties fairly. Still, the leader of the opposition also criticized the bill for excluding some community members from acting as sureties. But what they failed to acknowledge is that Section 1512 allows for defendants to act as their own surety once they can show proof of assets and are unlikely to abscond or reoffend. This is a progressive measure that benefits marginalized and isolated individuals who may not have traditional support networks. And when we talk about protecting the poor, we must not overlook Section 18 of this bill, as it also prohibits indemnity agreements. Why does this matter? Because it protects the poor from being exploited by those who offer to help with bail only to demand something in return, whether money or favors. Therefore, Mr. President, this bill does not represent the denial of freedom based on economic circumstances or criminalize poverty, as Senator Faber has said, but represents a fairer and more level justice system. It certainly does not balance the books on the backs of the poor, as was put forth by the opposition leader, but maintains a balanced approach, one that protects the rights of the accused while safeguarding the safety of society. And that is something I believe we should all stand behind. And for this reason, Mr. President, I fully support this bill. Thank you.
I recognize Senator Timbrell.
Thank you, Mr. President. I think it's Mr. President, I believe that this Bill 2025 is in fact a good bill. It's new, it's consolidated with new provisions. It speaks to what can offer, who can offer bail based on the issue at hand, which is the deciding officer, a justice of the peace, a magistrate, a judge. To me, it speaks of being responsible. Just in terms of the selection, I know that that Senator Faber have just asked that this list be expanded, which rightfully so. This bill also gives the opportunity for the refusal of bail to be appealed. And that really speaks into our democratic process as a society. The bill speaks of factors to be considered when granting bail. It alludes to the type of crime and punishment for the crime. Again, another good attribute of the bill. The bill creates accountability by means of the court when the defendant makes his first appearance. This speaks to whether the bail was granted or not. So, in a sense, a magistrate or a judge has the opportunity to review if the bail was in fact granted or not, and what the circumstances were, which it gives additional protection to those who seek the bail or access to justice. But, Mr. President, in reading through this bill at hand, I too had some concerns. And as I opened, I made sure that my initial remarks was some of the positive things that I see the bill does offer. One of the such case is where it speaks about a defendant who is released on bail may be arrested by a police officer. And it gives the conditions. It says without a warrant, if the police officer has reasonable grounds for believing. Mr. President, I find that to be very troubling. I love our police officers. I believe in our police officers. But I think we all know and would agree that there has been many cases where our police officers has irresponsibly used these provisions given to them. I truly believe that. It also speaks of, the second clause here says, a defendant who is released on bail may be arrested by a police officer or suspecting that the defendant has breached a condition of the defendant's bail or committed an offense while released on bail. So it's saying, in essence, if the police officer only suspect, what if we have police officers, like I said earlier, who have some type of ill intent? I'm sorry, Mr. President. Like I said earlier, I love the police officers. I know many of them, they're great friends. We're law-abiding citizens. But there has, in fact, been many cases where police officers has abused the rights that they have been given. And it would be unfair for me to stand up here and not make note of that as I make my presentation as it pertains to this matter at hand. So that concerns me greatly. Why are we giving the police officers such wide level of discretion? Why are we? That should be the way it works. But the matter of the fact is that there has been cases, and a lot of cases where the police officers has in fact abused their power. It also, another area of concern for me, Mr. President, is where it talks about persons exempted from acting as a surety. In point 7, it listed the General of the Belize Defense Force, the Commander of the Coast Guard, but I don't know why it did not list the Commissioner of Police. In point 8, it speaks about a commissioned officer, but I was, as I read that, it just, to me, just raised a question, why not just list the Commissioner of the Police there? He would be included. So, in my opening, Mr. President, I made these points because of what I'm about to say next. We live in a democratic country, and we believe that the rule of law must be what governs all of us, whether you have been suspected of committing a crime or not. Because, as the Constitution says, you're innocent until proven guilty. But for those listening to us in this session this afternoon by means of television or radio who may question, why are they coming up with a bill like this at this time when the public outcry to correct an ineffective, as I would call it, criminal justice system where the conviction rate is so low and criminals seem to be so emboldened to commit crimes in this day and time? I think if we are supporting the fact that we want justice for all, even those who are accused of committing a crime, then I think for the sake of those listening who have a great concern as it relates to the number of criminal incidents that's taken place in this country, I think it's right for me to make mention of the fact that, to their comfort, I know there's the 13th Amendment bill that is soon to be presented before this House. I'm not going to. But for the sake of those listening, Mr. President, I am saying this because in one sense I'm saying we support the bill. We recognize that the bill has need for some correction and improvement. But we don't want to give the wrong impression to those out there listening to us this afternoon that we are here tabling a bill, debating a bill that seeks to put provisions in place for people who may be people who commit criminal activities, and we're not taking them into consideration. That's not the purpose of why we are here this afternoon. We want to clarify. We are not supporting the bill to say we do not hold to our heart the concern of what the populace out there might be feeling, that our criminal justice system seems to be failing because the conviction rate is so low and people who commit crime seems to want to be doing it on a more rampant basis. I think it's important for me to draw the contrast this afternoon. I think it's important for me. It's important for me, Mr. President, to clarify to those listening this afternoon, that is not what we seek to do here. We believe that everybody has the right, as the Constitution gives them, to the process of getting a bail. But we don't want people to get the wrong impression that nobody in this honorable House is taking into consideration the public outcry that they feel as it relates to the fact that we have a problem with crime in this country. So this is the reason why, Mr. President, I feel obliged to stand and give my contribution on this issue. We want the general public to understand that we do have their concerns at heart. We know what they're feeling. And I'm saying that because from time to time I might meet with friends around a barbecue or having been invited to different people's homes and or in different settings where people raise these issues as it relates to how they feel about the level of crime that's taking place in this country. There's a great concern, Mr. President. People are worried. People are concerned. And I want to assure them that our support for this bill this afternoon is not in any way saying that we don't care about what their concerns are. I want to clarify that. Not because we're voting to support this piece of legislation means that we do not care and we're not concerned. And I also wanted to use this opportunity to raise the sensitivity of the issue, and I believe we all are aware of it, that people are really concerned. You look at the news every day and you see the amount of incidents of whether it's home invasion, it's people are being shut down in the streets through gang activity, or people simply don't feel safe in their homes, Mr. President. These are things that's very dear to the Belizean people in this day and time. And they're looking to us, they're looking to this honorable House to come up with the solutions to meet the challenges and the troubles that they are currently facing. And that's why I feel obliged to, in my support of this bill this afternoon, also make mention of the things that I said to clarify that we do care, we are concerned about what's taking place. And so with that said, Mr. President, I want to thank you for the opportunity to give my contribution to this bill this afternoon.
I recognize Senator Pitts.
Thank you, Mr. President. Although I know Senator for the Union Denison needs no assistance. To correct and clarify for you and for the listening public that when we make broad, general, and sweeping statements that the conviction rate is solely the responsibility of the director or the office of the director of public prosecutions, that is irresponsible, that is not correct. And let me tell you why. And when we say that our criminal justice system is broken or that it is not working, that is irresponsible and incorrect. Let me tell you why. The Constitution guarantees presumption of innocence. The Constitution guarantees equal protection of the law and freedom and liberties of the subject in the form of movement and association. Senator Galvez, presumption of innocence means this. You cannot be deprived lawfully of your liberty, go to jail, without the state's ability to show beyond a reasonable doubt that what they accuse you of doing is what you have done with evidence. And you see beyond a reasonable doubt? It is the very thing that safeguards the presumption of innocence. And so when you see our justice system through the involvement of the DPP and the office of the DPP, our good Senator Denison goes before it, presents a case and prosecutes where they are unsuccessful, it is not because they are incompetent, inefficient, or the system is broken. It is because the file they have with which to prosecute is in such a state deficient and does not rise to the standard to reduce, remove, and inhibit a man from his freedom of movement and liberty without having satisfied that he has committed a crime beyond a reasonable doubt. I mean, you have your record. You understand? You have your record to go with you. So I don't want us to take it for granted that we have a broken criminal justice system. I don't want us to use lightly the terms like presumption of innocence and that this bill does that and preserve it. And let me get to the substance of my intervention, Mr. President. Most welcome, because you see, one of the deficiencies I notice in here, and I have seen and observed Senator Courtney have the same experience and response. Those of us who are not versed with involvement with the law, practice of the law, or reading legislation, sometimes are in or interventions. Yeah, I won't say it, because I endeavor, my good leader of opposition business, not meet me with reprisal hereafter. But the issue of bail and creating a legislation to target bail came out of a situation where defense attorney practitioners were experiencing significant pushback from the criminal division in the High Court. The Association of Defense Attorneys were agitating to address the issue of bail. Now, the issue of bail arose because of one nuisance. Section 16 of the Crime Control and Criminal Justice Act that make reference to special reasons taken under consideration when granting bail. So don't, please, addressing our minds to a legislation like this is having to understand the background and the implications. And when Senator Faber said we're criminalizing poverty, that was not him being facetious, but him understanding that in application, the persons who are affected are marginalized people, and their ability to access is severely threatened. But I digress. So this section 16 that has to do with special reasons. On the one hand, some jurists were treating special reasons as sensitive to the accused. On the other hand, jurists were treating special reasons sensitive to the offense. Now, crime is not unique to Belize or anywhere. But our knee-jerk reaction to want to solve crime is causing us and inviting us to trespass on civil liberties and constitutional guarantees. Because what we're now doing is looking at an offense, a criminal occurrence, as a reason to say we will refuse your access to bail, or that when you look at the sections, I will point out, the threshold and the triathlon obstacle course you have to go through in order to access bail. We won't make it easy on you. So, let me point out that there was a decision by two jurists. First, now JCCJ Barrow, that treated special reasons as special reasons sensitive to the offense. Thereafter, we had Justice Legal, as he then was, who looked at it and said, like this does not really make no sense. And I'm sure Senator Denison could quote the case, I think it's Tomasino, that no, special reasons must be sensitive to the accused. Fast forward to present day, we have, and it is not that I am inviting any appreciation that we must feel one way or the other towards our criminal division judges who happen to be foreigners, but that those judges now come and they say that contrary to the decision that special reasons has to be to the accused, that it instead will be to the offense. And so we saw a broad, sweeping period up to now where bail generally get denied. Now, I don't know any of you if you asked for the white paper to the bill. None was provided when we got it, but one exists. In any event, the Association of Defense Attorneys, they were consulted initially since they provoked some treatment of bail. Now, this legislation as it stands, this bill as it stands, I cannot say with any certainty, and as far as I've been able to ascertain, that they have seen the final product in order to say whether or not they agree. And I hazard and cautiously say that that is not the case. Right? But a white paper exists. One was drafted by the same committee dealing with this bill and the 13th Amendment. Now, in Section 2, we have a distinction of commission officer and deciding official. There's a definition attached to both. What I wish to highlight is that where we have officers being afforded opportunity to grant station bail, there's a distinction between those who can above the rank of a corporal and those below. So in one part of the act, you have a constable being able to offer station bail. And then when you look at revisiting bail or challenging bail, they make reference to only those given by a corporal. So there is a lacuna there. Make it consistent. Don't provide for a constable in one circumstance or above the rank of a corporal, and there is no consistency throughout. Either constables will be included for everything or they be excluded for everything. An important feature and observation is the treatment of mentally unsound persons before the court. You know what our practice is, Senator Timbrell? Us throw the man in jail. Make Matos get some medication or injection. No Matos. Oh yes. No. Consider that. I learned recently that the only mental health professional in the government system indicated that he's leaving, and according to my good senator, has already left. Now, in law, unless there has been changes, my good senator, I invite you to correct me, that culpability is limited by your mental status or intent. Somebody who, for all intents and purposes, mentally unsound, commits a crime while mentally unsound, their culpability is limited to at the time how sound that mind was when the crime was committed. We good so far? All right. So now, here comes a mentally unsound man before the court. Instead of there being an order, and I don't want to make it seem unfair, because the truth is we have no mechanism, we have nothing to do just that. But what the court instead does is remand, and they go to the prison. For a person, despite unsoundness, is presumed to be innocent, his or her liberty is affected, not immediately assessed, but affected by being remanded to custody and left to languish. I don't know if you're aware, but these things, they do occur. A gross example of how mental patients are treated with respect to bail is there was a case in Jamaica. One of my batchmates did it. Succeeded. There was a mental patient in jail for 50 years. 50 years. Now, the point about criminalizing poverty is not just to say that we want to find a fancy catchword for what is going on, but there are persons who are otherwise at a disadvantage already, and when they come into contact, there are further disadvantage, and the chances of that disadvantage having to do with their impecuniosity, in other words, poor and broke, is very high. Right? So that is the point. Now, Section 4 sets out that you are given an entitlement to bail. And I say, but that sounds good, right? But I considered the nuance and the distinction between an entitlement to bail versus a right to bail. You know why it is so unfortunate that we are being invited to legislate for matters that have to do with constitutional protections? Senator for the Union will tell you, during that 30-month, $2 million PCC exercise, the issue of bail came squarely before it, and there is a specific recommendation for it. And that recommendation addresses bail substantively, in my view. When I spoke with the president of the Association for Defense Attorneys, I said, But I find it curious that bail, liberty of the subject, the presumption of innocence, it being a strictly constitutional guarantee, how is it that at no point any matter was taken in the court to address bail on the constitutional level? And valid though it may be, you know what the reality is, Senator Timbrell? Civil litigation is not cheap, you know. Civil litigation isn't overnight, you know. If you have a client who is arrested and remanded Monday, by Friday you could get heard before a judge for application for bail, as it is. Now, that is not to say that the bail will be granted, but at least for certain we know that either on a Wednesday or a Friday, you get to go before a court to determine whether or not you can access bail, to do a constitutional motion to address the bail issue. 2 years, 3 years, and money. So then I say, with respect to Section 4, that what I would like to see is not an entitlement to bail. Let whatever recommendation to address bail be dealt with in the Constitution, where it is provided that there is a right to bail. Now, Section 5, subsection 3, that has to do with the release of a person unconditionally. I like that provision, but I would wish for it to go further, because Senator Timbrell, pardon me? We practice this. We know about how this works. Because what happens in real life, Senator Timbrell, that because the Constitution says that you have 48 hours for which you can be detained, you know what police do? Hold up for that 48, let you go walk down New Road or down Queen Street and pick you up again. Start a whole new 48-hour cycle. So that section, I'm saying, it is recommended that don't stop at unconditional release. Expressly state how that unconditional release should look, that unless there is material investigation that leads to substantial evidence, circumstantial or otherwise, that points to culpability, you can't rearrest. Now, Section 5.5 looks good, you know, that when somebody is being remanded, you have the keeper of prison document the condition. My recommendation is that the obligation should be both on the delivering officer and the keeper of prison. You know why I say that, Senator Timbrell? Between transportation, have you ever heard of the term punk hole? Yeah, between transportation, man get put in a punk hole. And for Queen Street or wherever to Hattieville, blows. Put an obligate, whether they, you know that. That's a punk hole. They put you in the middle, 2 police on the end, and beat you while they're in the middle. Impose an obligation on the keeper of prison, as well as the police officer, to document the condition upon which the accused is delivered and received. And I go further to say this, and this is only because of my practice, and I don't share it because I want to, because it shocks the sensibility, at least mine. Where police have become, whether you want to call it ingenuous or disingenuous, to start to lay blows in areas you wouldn't think to look. Yeah, shock therapy in areas that I'm sure should you learn that not only Jesus you have to pray to. No, this thing is serious, because when you want to accuse a defective criminal justice system, this is the same system that says, if it is you come before me with a quote-unquote confession and I learn that you beat this man, you starve this man, you know, water this man, how is it that I will rely on your representation that he gave that of his free will and volition? No, those are the safeguards that are in place, and it is because we have those strong safeguards that we can identify where the shortcoming is. But perhaps you don't want to lay the blame where it really should be. It is not the criminal justice system. It is not the office of the DPP. It is our collective inability to hold the state accountable, whether red or blue, to put the capacity in the police department to be able to solve crime. So this has nothing to do with the justice system, because Senator Denison cannot successfully prosecute a case if he get a file with 3 paper and man where they lie. But this is not about the exception, Senator Denison. Section 5(8). Recommendation: the order for the production of an accused should be in writing, and disobedience of that order should be contempt and subject to contempt proceedings. Issuance of a warrant should be in addition to and after the said order is obeyed. Now, Senator Galvez, unfortunately, is not here. But let me show you how the financial situation of an accused could undermine the ability to access bail. Because back in the day, bail used to be reasonable and affordable. But our knee-jerk reaction to crime caused judges to put bail at 30,000 and a number there, you know, to defendants who would have never had money for that. Now, the good thing about it is, and the bill provides for it, and it should be expressly stated, you could split bail. And so, Section 510 should do that. What is also in the bill is that even when you're offered bail, if you're not able to take bail, there is a revision process by the court to revisit those accused who are not able to take bail and work with them in an effort to make them take bail. So you have that positive aspect on the one hand, but let me show you how it counterweighs on the other. You and I, being law-abiding, we understand what it means, I'm hoping, to give surety and recognizance, right? And so you know a quick for run go sign bail for nobody, right? Because you know how serious that thing is. Well, have you checked the provisions in this bill that are outright deterrents for people to offer bail and recognizance? And I do not believe, if we're saying that we are on the one hand ready to avail the accessibility of bail, on the other hand we introduce a kind of scrutiny to sureties and those providing recognizance to the level where we are looking at them with a side eye as if though you will be subjected to serious oppressive procedures once you come in to the system of providing surety. One of those examples is, let's just say you provide surety, you qualify as somebody providing surety, you're accepted as surety, and then you decide, man, me don't want a pastor, man, this boy I don't believe in a God, he went down the road, go do what he have to do, and you want withdraw your surety. That is possible, you know, but you know what this bill says? By application. You know what application mean? Lawyer fees. And I know they are the solicit for work, you know. And to make you understand that the average person who find themselves in this condition, these circumstances, will not be able to access. Like, why are we making it harder or impose hurdles when, if it is, we are meant to afford something, but on the other hand, we're taking it back? Now, when you look at the considerations for which a deciding official determines bail, this is why I say we have not made enough inroads. It's a long list, and I will not read it, my good senator, but I will refer to it so that you know what section I refer. That is section 6. And when you look more particularly at section 6, subsection 2, when you appreciate those provisions, you realize that what we are codifying is special reasons being special reasons sensitive to the offense. Considerations for the accused, very slim. They leave, as always they do, any other factors that appear to be relevant. But when you start out with things like preserving public order, yeah, you know to get that. Preventing crime, yeah, you know to get that. Now, section 6, 1B, Roman 4. That has to do with a person who has been admitted to bail, and he or she failed to appear for a court hearing, or for all intents and purposes failed to appear. And you say, but that is expected. Considerations to bail is to assess your likelihood of coming back before the courts to answer to charges to you. However, having created the offense of failing to appear, the section proceeds to say it is a defense if you have reasonable excuse for failure to appear. But what happens in between then is an automatic revocation of the bail you're on. You're gerrymandered, and then you have to wait to come back before the court for them to hear you whether or not you have a reasonable excuse. You see that? Senator Faber shared a circumstance where if you're charged in one judicial district, you have to travel. Like, at what point, having accommodated considerations towards the vicissitudes of life, have we also lost the fundamental principle of presumption of innocence? So if it is you fail to appear, bus could broke down. You could get knocked down by your way. Your house could catch fire. Any number of things could happen. Listen. That jack then could have jack you and take away your phone. Who knows if you have a lawyer? But the thing is, if we can accommodate that, why isn't it then that considering reasonable excuses is a defense? Having secured the person, why shouldn't it be that that person should forthright be brought before a court to determine whether or not he has a reasonable excuse before you revoke bail, before you deprive him further of his liberty? And I have other observations and concerns in section 16. And when you look at the lists that are for consideration, like I've said, they are generally, if you are in the arena and the practice, they are not accused sensitive. Senator Courtney, I am provoked to ask, when was the last time you did a bail application? Long time, years ago, and I am sure even you, with the skill you hold, when faced before a justice, the case no call no name, you see that beard when you left? Peel face. All the hair you want to pull out. It done gray. The next thing that will pull out the hair out of their head, because he'll be frustrated. And that is the reason why the Association of Defense Attorneys, they pushed for treatment on bail. And what the president has said, and I've checked, is that all that could have or should have been done is amend section 16 to say special reasons has to do with the accused and not the offense. And that may clear up everything. Fine, we have a whole bill. There are things in the bill that is good, but we've lost the impetus for which there ought to have been treatment. And then, Senator Timbrell, in the bill, it provides a revolving door of consideration and reconsideration for bail. So if you were taken for bail, you were denied bail, or you're not able to take up bail and you're remanded, the court is there after every 3 days, I believe, so often, to bring you back up and check what the circumstances to see how you can either access bail or be considered for bail anew. This is the justice system where you think broken. This is the justice system we're already oppressed with backlog. This is the same justice system that we are legislating without making any collateral or correlative support to it in order to meet the needs of this bill. How many magistrates do we have, you know? Much man they commit crime. How is it that we will attempt to legislate in a vacuum without appreciating whether or not we can, the existing infrastructure can support a revolving door of consideration and reconsideration of bail? I heard Senator Galvez make reference to the ability to appeal bail, and that when offering bail or refusing bail, reasons are provided. Senator Courtney, Senator Dennison, we know how the reasons thing work, you know. You know how long you could take before you get reasons? Man, Senator Courtney, we wait years just to get transcript for a matter on appeal. It doesn't serve us well to legislate in a vacuum, not appreciating the practical implications. And what is there, though, is that in some circumstances, you may be offered bail. Now, there is a provision that says, should the Crown appeal a decision to offer bail, you know what happens automatically? Bail is revoked pending the appeal. Listen, when ordinarily what we had before is that you can apply for bail pending appeal. That they get revoked, you know, that they get repealed, just so you know. No, that will be, let me tell you, if you look at the sections that are being repealed along with this, when you look in the schedule, section 2 something of the Senior Court, section 220 of the Senior Courts Act is being repealed, and that is the section that deals with bail pending appeal. Yes. So, I mean, repealing it, the burden here now, the distinction though is that where there is an appeal by the Crown on the issuance of bail, what happens practically is bail is revoked automatically, pending the hearing of the appeal. And you could check, and in your interventions, you know, another thing that is striking Senator Timbrell and Senator Galvez on the presumption of innocence, when you go for a bail hearing, you go there with your charge sheet and a summary of facts. Now, I find it inimical that the Crown presents this document called Summary of Facts, when, for all intents and purposes, it's an allegation. No facts, but then treat it as facts. And remember, your right to a fair hearing is what affords you that presumption of innocence, and only until you've had that, then a determination can be made of your guilt or your innocence. But you know, in this legislation, a deciding official can look at the strength of a summary of facts to determine whether or not he or she will refuse bail. But what happened to the presumption of innocence? How we just treat an allegation and the circumstances in the allegation as if though they're factually correct, to the level that it will invite them to deprive you of your liberty when you have not even had the opportunity to test the Crown's case. So I have fundamental issues with how we're not observing and applying what our Constitution guarantees and how it plays with the law. And it is because of those constitutional guarantees, as I've said before, that is why sometimes you will see there are no convictions.
Senator, could you please wrap up your remarks?
Of course, Mr. President. I would like to conclude by saying this. There is no legitimate basis for using the competing interests of crime and violence to sit, not you, figuratively speaking, in an ivory tower where you do not see it, feel it, or know it, should invite you to make it okay to legislate in a way that will affect only a particular section of society. One of the areas of this bill that I found concerning, we exempt certain persons from giving surety. I don't know how many of you gentlemen in here have children over the age of majority, but could you fathom, Senator Courtney, that Gavin would be accused of some crime? You being a responsible, loving father, they are telling you by virtue of you being a member of the National Assembly, you can't give surety. When you are the parent, you can assure he lives with you and in your house and he shows up, but they're telling you you can't. And I am saying we already have these strictures in place to make the citizen understand how serious it is to offer surety and recognizance and the consequences and ramifications of doing it in situations where you cannot secure the accused attendance at his further court hearing. Why must we then, and perhaps you, Mr. President, would enjoy being free from a duty to provide surety to a family member, but for me, I am saying citizens should be free to engage with the system, having an understanding of the ramifications, and that kind of exemption in the schedule, it is unnecessary, because the consequences of providing surety where the accused does not show up, to me, is sufficient. And so I end, Mr. President, by saying that a bill that is masked to solve a problem widens the space for problems. And so when the bill was meant to address a concern, it has opened it up to even more and further issues. And Senator Courtney, I ask, this magnanimity to receive recommendations, I am indebted and I appreciate it. And we will always agree to disagree on some matters, but I would invite a kind of sobriety whenever we're dealing with constitutional issues or things that have constitutional underpinnings. And the good cop, bad cop, where we may all have our respective styles, or we may all have our respective objectives to discharge. This one bill, I sincerely invite the government to have us stand down, to have a look at it, to see where we can cure certain areas and strengthen others. Because it would not be in good keeping to, as Creole would say, throw away the baby with the bathwater, because there are some good aspects in the bill, but there are some other aspects that are of deep concern that I think we could work together and identify it and go back to the drawing board. Let the Association of Defense Attorneys actually see it and contribute. They didn't have that opportunity in the end, as I understand. Thank you, Mr. President. I yield.
I recognize Senator Chanona.
Thank you, Mr. President. A lot has been said here today, Mr. President, and I will join those who say they do not have a law degree. But I think what stood out to us immediately with this and the feedback we were getting is a sense that the public social contract is wanting or needing some attention, because I think there is an innate want to trust, but there's also a kind of in-your-face reasons not to. And to piggyback on something that has already been shared in terms of the responsibility of bail came out clearly in terms of, well, if we're setting out rules for who should get bail and under what circumstance, can we talk about discretion to make sure that there's no discrimination that can come into play? But some of our membership immediately went to a recent case, and it blew up on social media for a time, of a child that had been raped in a village, and the person got bail and went right back to the village. and the child had to relocate with her sibling to another part of the country, at the family's expense. I read Schedule 1, and Schedule 1 says that should not have happened.
That's what happens now.
So that's what I'm saying. But that is the case that the public is seeing, because I take the point, you all are working every day with a system that very few people on the outside of that system can see. So these are the cases, and it's a lesson that the public then becomes exposed to the anomalies. And this is I join the call for the education around this, so that there can be some collective discernment and mapping a way forward to make sure that consciously and collectively we're not, I think the expression was broadening the room for error, but to make sure that we're getting it right, so that we're creating the circumstances conducive to making sure those who deserve bail should get bail. But I just call it out, Mr. President, because I hear it, and I think we've heard it here today, and I want to point out to senators that I think it is important that at all times everybody gets their piece without feeling there's any type of intimidation and hesitation. So I like that we're in that space. But I do think it's important for us to have these types of conversations, because I think these are the hard conversations that, as Senator Timbrell called out, there is an expectation that we should be having at this level to make sure that we can be accountable to ourselves. And that if we end up in any of these situations, that we can know that we played a role in making sure that we or our loved ones would be subject to the same system as anybody else, any other Belizean. And that, I think, is the thread I'm seeing, the commonality in all the interventions to date. So I just wanted to highlight that, Mr. President. Thank you.
I recognize Senator Herrera.
Thank you, Mr. President. Mr. President, before I start, and I just have a few comments. One of the things I always note with these types of legislation is that victims are seldom mentioned, and that there seems to be a gravitation towards those who engage in these criminal activities. And I think that it's extremely unfair in many respects. And I understand some of the hardships. that some of the individuals go through in terms of obtaining bail or when they're going through the system. But yet we cannot bring back life. We cannot bring justice to some of these crimes that take place on a daily basis. And I think that sometimes that get lost in these discussions. And so today, for all the victims, for all the persons who have been wronged by these criminals, they need a voice here too. Mr. President, there are several typos in this bill. On page 22, well, yeah, I could do it in committee. Okay. Mr. President, there's one area I want to highlight on section 5. And as well as in several areas of the bill, it talks about giving bail within 8 and 48 hours. And now, I think that, well, if someone is arrested at 4 o'clock on a Friday afternoon, the courts are not in session on Saturday and Sunday. So does that mean that that person is automatically and unconditionally released on Sunday? And if that is the case, where they will then be further remanded, and I don't know how that system internally works, but perhaps then it should probably state that if someone is arrested on a Friday afternoon and 48 hours elapses, or if there's a holiday on a Monday, that perhaps there should be a caveat in there that states that, well, it will be on the first working day of the court session. But I think, and in several, I've seen that mentioned several times about the 48 hours. And I think that is certainly something that I think is important to be addressed, or perhaps there's an explanation for it, I don't know. But that one certainly stood out to me when I was going over it. And then at 13, section 13, I think I addressed that one already, I'm sorry. That was one of the typos I had indicated. Yes, the 48 hours was the major issue I had on this piece of legislation, Mr. Speaker. I think that perhaps we could get some clarification on that in terms of how that would work if someone is arrested on a Friday, or if there's a holiday, if there's a national holiday on a Monday. And again, I just want to wrap up again by saying that, you know, I think that we should also look at the victim's side of this as we're going through this legislation. Thank you.
I recognize Senator Dennison.
Do I need to speak, or will pull the bill? Thank you, Mr. President. I have very little need to repeat much of the legal lesson that was just so eloquently given to us for free by my learned friend, Senator Pitts. No, I will join her in what she has said, and especially in relation to the mischief that actually caused a call for this sort of look at the bail provisions. It really is a difficulty of interpretation of one particular section. And I appreciate that we're trying to consolidate all the provisions on bail. I think that's an exceptional move, and I commend it. However, I commend it. No buts. I commend it. It's a very good effort. As I read through the provisions of the bail bill, I am reminded of all the things that Senator Pitts spoke about, what presumption of innocence means, both for the victim and for the alleged perpetrator, the constitutional safeguards for your liberty and equal protection of the law, the need to balance that with the public safety and the risk assessment. The purpose of bail is quite frankly, as Senator Faber has said, to ensure your attendance at court. And whether the safeguards for those risks can be mitigated in such a way to secure your attendance. It's debatable, but in our current legal system, you can try to wrap your quote-unquote right to bail in presumption of innocence, the protection of the law, and your right to your liberty. But there's not an expressed right to bail. In fact, in our Constitution, bail is given not particularly as a right, but as a remedy only where you have not had a right to a fair trial within a reasonable time. There's a big debate about that and what that really means for the justice system. So I commend the government for taking this bold step at Section 4, but I caution, like my friend Senator Pitts, that we must ensure that the Constitution is used to give teeth to this provision, because I don't think anyone will challenge an entitlement to bail. I can't foresee that anybody will. But based on how it's worded in the Constitution, we could ensure that we reflect this policy position in this bill in the Constitution. So there are a few things I will raise in committee, so I'll just skip over a couple of them with your permission, that we will raise it in committee. Senator Courtney, Leader of Government Business, some of the definitions and like that. I want to read a particular provision for the people of Belize to understand the importance of this bill, because this is without doubt one of the very progressive pieces of legislation that I think we're going to be doing here, at least so far. This provision that says, and it's at clause 5.3, my note actually says, love it. It says, where a defendant is arrested or detained on reasonable grounds that the defendant has committed an offense and the defendant has not been charged with the offense within 48 hours after the arrest or detention, as the case may be, the defendant shall be released unconditionally. Senator Pitts made a very powerful statement on why that is important, but the importance of this cannot be understated. The abuse of the detention period needs to stop, and police officers, you know who you are, stop doing it. So I want to ensure that we look at the considerations for deciding the question of bail and ensure that they apply for all the circumstances under which they apply for bail. The interplay between Section 6.1 and Section 5.1 is very important. I think we should take a second look at it. How 5.1 and 6.1 work together, just to make sure that it captures what we intended to do. I commend 6.2K for acknowledging the mental health profile as one of the issues that is for consideration. But it reminds me that there's also something that's not taken into account for bail is the physical profile and health of accused persons. Particularly, I know the question of whether you have diabetes, that sort of thing comes into play. Well, came into play recently. I wanted to take this opportunity to remind the Commissioner of Police of the special areas under the Crime Control and Criminal Justice Act that is referenced in this bill that gives him some powers that I think he should use instead of emergency powers, which I will not discuss here. And because we haven't done the families bill, we will need to look at some changes. I know it's a question of interpretation, but under section 7(2)(d), the requirement, this formulation strikes me that the people who drafted this bill are not intimately familiar with the criminal justice system, point blank. And I make no apologies for that. There's some very good people, and I'm sure they mean well. But a requirement that the defendant inform the deciding officer and the officer in charge of the nearest police station before the defendant travels outside of the jurisdiction or the community where the defendant resides. That's I don't think I've ever seen that sort of condition in bail. And in fact, this is a little weak compared to the conditions that usually obtain, but I leave it at that. I will say, you know, I like mess with drafters about copy and paste, but when I saw the wearing of electronic tracking devices, I wonder whether that was a copy and paste or we are progressive as a nation and we have them in country and who's going to pay for them, how we source them. I genuinely wondered whether it was a copy and paste or that's something, it's a policy decision that we're moving forward with. If it is, it's very progressive, I commend it, and I just hope that we put in the infrastructure to make sure that we can secure them. I will rely on my friend's position in relation to all she has said about the schedules. I don't think there is any need for me to repeat what she just said, but I end by repeating the request that we hold this bill just a bit for reconsideration, retweaking, because honestly, I agree with my friend that just section 16 of the Crime Control and Criminal Justice Act needed to be amended. Because the systems that are legislated here work. Those systems are in place in the court, and the court is being very efficient with how it's managing bail right now. And I don't want us to then put in legislation that sidetracks the flow of that system now. So just I end with that. Thank you, Mr. President.
I recognize Senator Guerra.
Mr. President, this really, and I must say in my practice, I've had the opportunity to deal in my practice as an attorney. I've had the opportunity to deal with multiple bail applications before the court. And I think I should preface my comments by saying that what is reflected in the bill, a lot of it is already implemented in practice so that practitioners, judges, litigants who have to frequent the court would be familiar with a lot of what is already being codified. The benefit of this bill is that one can now access it in black and white instead of having to look for precedent, looking for precedent in order to determine what considerations are applicable. That's the primary benefit to this bill. So with that preface, Madam President, I'd like, Mr. President, my apologies, I'd like to now address some of the issues that fellow senators have pointed out this afternoon. So I wrote it down. One of the issues raised by Senator Farber, and I quoted him as saying, the bill presents threats to fundamental rights. As Senator Pitts alluded to, this bill, Mr. President, is firmly grounded in what we as Belizeans enjoy and what is called the presumption of innocence. That is, that all Belizeans, all citizens, are presumed to be innocent by the highest law of the land, the Constitution, unless proven guilty by a competent court of law. That means that one's freedom ought not to be deprived unless there is good reason for that. That is a presumption which we all enjoy. Mr. President, another concern that was raised related to Schedule 1 of the bill and the offenses for which only judges can grant bail. If one looks at the schedule, it relates to what we call indictable offenses. Those are serious offenses, so primarily murder, robbery, attempted robbery, burglary, aggravated assault, kidnapping, attempted kidnapping. These are serious offenses which already primarily can only be dealt with by a judge of the High Court. So again, it goes back to my statement. This isn't something new. It's already primarily being applied in practice. I am an attorney. Another issue raised had to do with the issue of absconding and the high penalties which attend to that. Now, bail is an opportunity for a defendant to maintain his or her freedom until convicted by a competent law. It's granted primarily in consideration of that defendant's commitment to return to trial, to show up for hearings. That is the primary concern that concerns a court when granting bail. So that there needs to be stiff penalties in place so that defendants don't simply up and leave the jurisdiction if they're granted bail. There was a concern that there's no provision for illness, for impecunious, for someone being poor, Mr. President. Both in the House by the Leader of Opposition and by Senator Farber here today. This bill makes it an excuse, makes it a defense if someone says, I could not have made it to court because of extenuating circumstances, because I'm ill, because I could not afford my bill to my bus ride to go to court. This bill provides for that. In terms of sureties, concerns were raised in terms of the fact that sureties must now meet certain qualifications. Now that already existed even before it was codified, meaning in our body of laws in Belize, we consider case law, Mr. President. And so it's important when somebody stands as surety and says, I will ensure that this defendant comes back to court. I will ensure that this defendant will comply with the conditions of his or her bail, it's important that the court considers that person's character, the relationship of that person to that defendant, that person's criminal history, because it's important for wider society to be sure that the person giving their guarantee, saying that defendant will come back to court, that that person's word is good. And so, respectfully, when the bill says we will consider A, B, C, it is with good intent. It is to make sure that defendants show up to court. Another issue raised, Mr. President, had to do with police officers, and to be specific, the bail bill says commissioned officers, which it describes as police officers above the rank of a corporal or a police officer in charge of a police station, with them being granted the right to offer bail. Now, that's already in practice. That's already possible. And the issue raised was that they might be biased and might not want to grant bail. Well, the bill provides that there is a right for a magistrate or the High Court to consider that denial as soon as that defendant appears in court, so that there are safeguards within this bill to ensure that that decision is arrived at in a legally sound way. Mr. President, another issue had to deal with virtual complainants and defendants being released on bail into communities, into homes where the virtual complainants reside. A very serious issue which has in fact happened in the past. This bill at section 6.2 codifies, puts into black and white that a court, a deciding officer, whoever it may be, the magistrate, the High Court, must consider that before he or she grants bail, so that a condition can be, Mr. President, that the defendant remains outside the certain community in which the virtual complainant resides. Another issue raised had to do with the revocation of bail if the prosecutor appealed bail. Now, the bill doesn't say that bail is revoked automatically. It says it may be revoked, so that a court will not simply revoke bail pending appeal, but will look at the specific circumstances and will exercise a discretion. And of course, the bill allows for defendants to apply for bail pending appeal. I'm just making sure I'm addressing the issues, Mr. President. An issue was raised in terms of informing the court as to a defendant's intention to travel. Now, what the bill does is It prescribes certain conditions on which a defendant can be granted bail. One of those conditions is that a defendant's travel documents could or must be surrendered to the state. That's one of the conditions that may be considered. But where a court doesn't require a defendant to surrender travel documents, it is imperative that a defendant inform the court as to his or her travel intentions, because a court must know where a defendant is at all times. Remember, the primary objective is to ensure that the defendant is available for trial. Mr. President, I think I've addressed most of the concerns I've taken note of. Before ending, I just want to say that there was an issue as it relates to decisions in terms of bail and the availability of those written reasons for the purposes of an appeal. This bill provides a standard form in one of the schedules for written reasons to be provided, outlining why bail is either granted or denied. And so this bill addresses that concern. So we say that this bill is indeed for the poor, it is for the vulnerable, it gives them clear rights, but at the same time, it balances that against the rights of wider society to live in peace. Mr. President, before ending, I'd like to quote one of the principals of the Association of Defense Attorneys who recently appeared on a morning talk show just earlier this month. The kisse no call no names, and I quote, because it's enlightening what this seasoned attorney had to say about this bill. The AG has tackled some of the systematic structural problems facing the country with inadequate laws. He has come with modern laws. We are going to have in Belize, for the first time in history, a law that will deal with bail. We support the AG 1,000%. I can add nothing to that, Madam President. With that said, I too proudly support this bill.
I recognize Senator Zetina.
Thank you, Mr. President. To be quite frank with you, I wasn't going to give any input, given that Senator Pitt had, to my belief, given us a very detailed recommendation in her belief that should be considered with this bill. And, you know, I will keep standing whenever we're faced with what was just portrayed. And I want to put on record that it is very much unfortunate and true, at least from our side, when we heard lead senator of opposition, Patrick Faber, speak. He did not say that he opposed the bill. And so, whenever we see raises whenever we have recommendations, backed by reasons rooted in the best interest of the wider public, we will keep our attempts to raise those concerns. And let me be clear, what was brought forward regarding the Bail Bill 2025, it is not partisan, it is principle. For example, we had heard, I don't want to pick on you, but Senator Galvez speak. And I will reference clause 15.2, ban the reuse of same property as surety. For example, a family has only one titled land. Say, for instance, the eldest son was charged last year with a crime, and now there is the youngest brother with a different matter, right? The land can't be used again. They don't have a second property. Say, for instance, they don't have any rich member within their family. And so that person stays in jail. And presumably, by all accounts, one is innocent until proven guilty. Right? So, in this case, he would be not granted bail, not because he is found guilty, but because he does not have a second property as surety. So that would be classified as poverty, right? Am I reading that correct? And thus, our input is based on sober reading. We do so not for political mileage, but because we believe laws should be reserved for everyone fairly. So, while some might be quick to dismiss our input, our recommendation from the opposition, we're only doing our job, scrutinizing this or any bill, as I am concerned, with a sober mindset. So, again, we're here to strengthen legislation, not sabotage it. We're here to scrutinize, not politicize. And that, to me, is what a functioning democracy demands of us. Clause 14.2. Let me just put this. Clause 14.2 talks about persecution can delay release after bail is granted. And so, for example, a young man, say, in San Pedro is granted bail, and his mother tries to scrape together everything to pay the surety. But then the prosecutor stands and says, I intend to appeal. And the youth is kept locked up, right? Up for 2 more days. And under this clause, clause 14.2, which prosecution can delay the release after bail is granted, prosecution, sorry. What if it's on a Friday? And I think someone had alluded to that already. And so now he is behind bars until Monday. And so that is, to me, that is a justice, and it causes unnecessary delay. So this, for example, needs to be looked at. There's another one that I found very much alarming, Clause 21(1). Minister may amend bail offenses and penalties by order. So this, to me, is a huge red flag. Bail conditions and penalties can be changed based on whose recommendation? So this must come back to, or I would say it needs to be revised. I recommend that this be looked at. Let's not give unchecked powers to any minister. It should be left up to the court to decide. And I stand by this today, tomorrow, any day. Also, Clause 5(5), bails for minors handled by family court. I support the protection for minors, but what happens when parents is absent or the home is unstable, which you find very much often with troubled youths? And so this bill doesn't say. So I believe this also needs to be looked at. I want to conclude and say that, and I've been saying it throughout today, I will not rise to oppose just to oppose for sake. I rise to speak and hopefully try to improve what we're discussing. And so this bill, while does have merit, but it must also have compassion. Let's not pass bail bills that look tough on crime, at least on paper, but then on the other side, it is soft on fairness. Let us pass a bill that is firm, fair, and fair for all Belizeans, rich or poor, from all walks of life. Thank you.
I recognize Leader of Government Business.
Mr. President, I will be brief. I'm not sure what or who Senator Zetina was responding to just now. I have not heard anyone say that opposition is against this bill. So I'm not sure what exactly was his concern. Nevertheless, there are a few things I want to comment on. The first is, this bill is not revolutionary. It is not attempting to change the existing framework for bail, for the grant of bail, for the refusal of bail that exists at the moment. It is attempting to put in legislative form common law position, or I should put it the next way, different statutory provisions as interpreted in cases, common law position, into one place so that everyone can know what the law relative to bail is. So I want to emphasize that it is not changing in any significant way the existing bail framework in Belize. I emphasize that because, again, there is no intention here, has never been the intention here, to prejudice, punish marginalized sectors in our society. there is no benefit, there is no rationale to select any sector of our society and to put on them higher burdens than currently exist for the grant or refusal of bail. That is not the intention of this legislation. I have heard it said repeatedly. I'm not persuaded that it does that, but I want to put on the record that that is not the intention of the legislation. Thirdly, Section 5, subsection 5 of the Constitution speaks of the entitlement to bail, not a right to bail. I emphasize that purely to respond to the points made by Senators Timbrell and Herrera. There is a need to strike a balance. One, the presumption of innocence is sacrosanct. Two, our societies, our communities are entitled to live in peace as far as is lawful, to be able to enjoy a standard and quality of life where they are not confined to their homes, where they are not fearful to walk on the street because they are persons who will cause or threaten to harm them. The other side of the coin, is to ensure that we do not go any further than the Constitution permits in the derogation of rights and freedoms that are guaranteed by the Constitution. And so bail has to be looked at in the context of, one, ensuring a person's turn up if they are charged. Two, preventing the repeat of any offense if that person is likely to do so. Ensuring the integrity of the judicial system. No interference with witnesses, no threats to virtual complainants, etc. Senator Dennison is familiar with these things. Where a person is seeking to undermine his trial or her trial, we have to put in place some regime to ensure that that is minimized. And so there are these objectives that the judicial system needs in order for it to operate fairly. This bill, I repeat, recognizes the need for a balance and continues the existing bail framework and does not attempt to change it. All of that being said, listening to everyone, I have consulted with the Honorable the Attorney General, and he has agreed that it should remain in committee so that we take it along with the magistrate court bill and do all our discussions in the judicial area, this reform area, and then we bring back one bill after we have that discussion. So, Mr. President, the intention is to leave this bill along with the magistrate court bill in committee so that we deal with that during the recess, and when we come back in September or early October, we hopefully can pass these bills with amendments that we regard as necessary. I say again, it is quite easy, I believe, for us to have forced through this legislation today, but we gave a commitment that we will entertain genuine, reasonable proposals, not criticisms, proposals. They have been made. The Attorney General says, let's hold it in committee, entertain them, have our discussion, and come back. So I want to thank all the senators who have contributed to the debate on this bill. And Mr. President, I ask that the question not be put, but that we hold it in committee. Madam President, the clerk is correcting me in saying that we should read it a second time and then hold it in committee. So I ask that the question be put on the assumption that it will be held in committee. Thank you.
Honorable members, the question is that the bill for an act to repeal and replace the Bail Reform Act, Chapter 100 of the Substantive Laws of Belize, Revised Edition 2020, to reform the bail framework in the criminal justice system and to provide for matters connected therewith or incidental thereto, be read a second time. All those in favor kindly say aye. Those against kindly say no. The ayes have it.
Bill for an act to repeal and replace the Bail Reform Act, Chapter 100 of the Substantive Laws of Belize, Revised Edition 2020.
I recognize the Leader of Government Business.
Madam President, I rise to move the second reading of a bill for an act to repeal and replace the Law Revision Act, Chapter 3 of the Substantive Laws of Belize, Revised Edition 2020, to modernize the system of revising, consolidating, and editing the laws of Belize, to establish an official Law Reform Commission to allow for the laws of Belize to be reviewed and reformed on a systematic basis, and to provide for matters connected therewith or incidental thereto. Madam President, this one is not a complicated bill. It is a bill that simply seeks to bring up to date the law revision process and to introduce the provision for a law reform commissioner and an ongoing law reform process. This is, in my opinion, long overdue, and I will leave it there.
I recognize Senator Patrick Faber.
It seems that whenever Senator Courtney says it's simple and academic, we don't have the same view. But I do appreciate that this is something that has to happen as a matter of course, given all the changes that we make to laws over time. Madam President, we therefore suggest that this is something that is necessary, yes, but we also have our concerns about it. Under Section 7, for instance, the Law Revision Commissioner is granted very broad powers to clarify language and simplify phraseology and even reorganize laws as he or she sees it fit. While these powers may appear harmless, as you heard Senator Courtney just allude to, they open the door to changes that can alter the meaning and substance of the law, even if inadvertently doing so. I don't know, our experience, and it's not with the laws of the land, just using our internal struggles in the UDP as an example of what law, and for us it is the constitution of our party, how that can be misinterpreted and wrongly used by the interpretation of individuals. And in fact, we have seen, I mean, that aside, the expected criticism that can come from our colleagues on the other side, well, that is the UDP, their laws probably were not written properly in the beginning, but the laws of the land have also demonstrated from time to time to be problematic when it comes to interpretation. And so when what is put in the hands of so many, the cabinet who first makes recommendation for these laws, but before that even happens, the respective line ministries that make recommendations to the cabinet then endorsing this, sending it to the House of Representatives, and then from the House to the Senate, it has so many hands-on in terms of what is intended, and then to place it all in the hands of one individual in order to interpret if something is not straight and clear can be indeed very problematic. Secondly, Madam President, the troubling use of retrospective orders is an issue. Section 8.2, 9.2, and 24.3 allow the Attorney General to correct errors or omissions with retrospective effect. This means that changes can be applied to the law retroactively, potentially affecting past actions and legal outcomes. This, Madam President, is a very serious threat to the principle of legal certainty, which is the cornerstone of justice in any democratic society. Laws must be predictable. Citizens and businesses should be able to act based on what the law says today, not what it might be declared to have meant later on. And we're not on the 13th Amendment yet. I'm not anticipating the debate. Thirdly, Madam President, the over-centralization of authority in the Attorney General is a concern. The bill places the Law Reform Commission, the Law Revision Commissioner, the appointment of staff, the setting of fees, the approval of updates, and even the pricing of legal publications squarely under the control of the Attorney General. While the Attorney General holds an important constitutional role, concentrating such broad powers in one office undermines institutional independence and opens the door to politicization of legal processes. And before Senator Courtney makes it personal, I want to declare that Anthony Sylvester is my very good friend. Somebody who I've worked with and I have the world of respect. He and I taught together, in fact, at the Anglican Cathedral College, and are extremely close friends. So this is not one of those instances where you can say that I am attacking because of the individual. In fact, I try not to do that. This is, in our view, something that can affect the revision of the laws tremendously because of the office and what is being put into this office for it to do in this piece of legislation. And then, Madam President, fourthly, is the lack of a clear mandate for public participation and consultation. A true reform process would include the voices of the people. Although Clause 32 allows for consultation with technical experts, there is no express requirement for public input on proposed reforms. This, we believe, is a missed opportunity to foster trust and ensure that the law evolves in a way that genuinely reflects the needs and aspirations of the society and not just a few or one or two individuals, as is our concern about this particular piece of legislation. Madam President, these concerns do not negate the potential benefits of the bill, and I need to say that we believe that it is something that is necessary. I started out saying that. But modernization must not come at the cost of democratic safeguards. Accessibility must not override accuracy and legal certainty, and reform must not become a tool for unchecked executive power. I strongly urge, Madam President, that this bill again be referred to a select committee for careful review. Let us ensure, as we've done with now 2 pieces of legislation since I've been in here, which gives me hope, that we do not simply pass a law to update our books, but that we strengthen the very foundation of our democracy and protect the rule of law in Belize. We owe the Belizean people and our future generations the integrity of this honorable Senate. Thank you, Madam President.
I recognize Senator Glenfield Dennison.
Obliged, Madam President. Madam President, the Constitution empowers the legislature to make laws, and for the peace, order, and good governance of Belize, I see inside that the responsibility to ensure that the laws that we pass really are consolidated, reviewed, and from time to time we reform them where necessary. So I commend this piece of legislation. I will only use the occasion to highlight a few things and repeat my call for a chief parliamentary council to be attached to the parliament, so that we can start the process of drafting the laws to ease the process of reviewing and revising, reforming the laws later on. I think it's an important aspect of our development as a country, especially as we're passing a lot of legislation that would need to be amended from time to time, that the ability to find where the law is by ordinary citizens of Belize is accessible, that we can know with certainty what the statement on a particular piece of legislation is. For example, if you had pulled up the, I just refer, Madam President, if you had pulled up the Central Bank Act, it would have been amended 3 times, and this would have been the 4th. And so, since those 3 amendments, there has been no consolidation, and you have to be, you have to know where to look for law. So this move towards reforming the laws is an exceptional move for our country and our development, and I commend that effort without reservation. The point that I was making earlier about the Chief Parliamentary Council, because we don't have that mechanism, I would have liked to have seen some sort of tie to the Parliament, but I understand the use of the Attorney General where it's there, but I really feel that this is a function that ought to be attached to the Parliament. The Law Revision Commissioner has some, as I had pointed out earlier, Madam President, technical requirements for qualifications, one of which is that they be an attorney at law not less than 10 years standing and have not less than 7 years experience as a legislative drafter. Madam President, this is the type of formulation that I appreciate, where we are making certain offices and we see upfront what we want that person's competence to be. And so this is a very good piece of legislation here. I only, as the Labour Senator, repeat something I've already said here, Madam President. If we ask for qualifications like a judge, we must pay like a judge. So this is 10 years experience. Hector, you reach it? 10? Senator Guerra? Good. You could qualify for this. So a High Court judge in the Constitution says 5 years. I know that's not practically that's not what we actually look for, but the Constitution says 5 years for a High Court judge and 15 years for a Court of Appeal judge. This is asking for 10. So along with the other offices that I keep asking for a raise for, the Law Revision Commissioner goes in there along with the DPP and the Ombudsman, the Auditor General. I keep asking Senator Guerra every time. I say these people are independent and they need to maintain it. In fact, the Ombudsman actually says he's to be paid as a judge. And one other person, I can't remember off the top of my head, Contractor General, their legislation actually says that they're to be paid as a judge. Poor DPP, hers doesn't say that. I feel fair. So, Madam President, I really do make that call because I think if we are to attract the caliber of person that we want to do this work properly, this is a very highly specialized skill. In Belize, I can only think of 2 people that would have the type of skill that is required for them, and one of them is already engaged with the government. One of them is at FSC. I will add my good friend, Deputy Solicitor General, to it, Shepard. But it is a skill that we need to keep and retain in Belize. It is something that if we do not allow for the capacity building to happen here, that we will keep losing those people to brain drain. And I don't think that that is something that that's not a route we should go, Madam President. I only ask for consideration for the preparation of the electronic database in line with my request for the laws to be made publicly accessible and free. Madam President, lawyers will tell you they pay you not to know the law, but to know where the law is. I think it's time we end that practice. I think the understanding of the statement of the law should be something that every citizen should be able to access and read in plain language what the position is on any particular issue that they have. And so I commend this keeping of a database to have it be some sort of user-friendly, smart, searchable database that is in the public domain. You will know, Madam President, that Parliament took the lead in making laws accessible to Belizeans and having it on the Parliament website. I believe that practice may have started in 2015. That was visionary in posting every single amendment act that has come. So if you want to know, yes, you need to do a bit of consolidation, but that was a great step in the right direction to have all the amendment acts online in folders, properly organized, properly cataloged, so you can just go and look. When you have a piece of amendment bill like this, you can simply look at what the notes are on what other laws have amended it, and you can go and find it on Parliament's website. That, Madam President, is visionary, and I thank the staff for continuing to update it. I think that puts us a very long way. However, because now we would be having a law revision commission and commissioner, law reform commission and law revision commissioner, I think we have to do better. I don't see why, if we have a dedicated office to consolidate legislation, to look for errors, that we cannot go further than what the Parliament has done with its limited resources and have a similar type of portal that's maybe searchable, and we can know exactly what for example, if you want to know what the composition of the board of the central bank is, you can just do a search on that and it can bring it up for you immediately, what the posts are, including whatever amendments come later on. So, and I want to add here that searchable feature needs to be manipulatable to a particular point in time, because what your rights are at a particular point in time is important for you to know. And so it's just that type of thinking that I would like to go into the creation of this system, Madam President, so that we can know for certain what the laws are, what the true statement of the law is, and how we are to treat with amendments going forward. Madam President, I say no more, and I thank you.
I recognize Senator Sheena Pitts.
Thank you, Madam President. I rise to support the bill. And I now invite the leader of government business to perhaps take the same course with this bill as the two previous ones. And the reason I say this is as follows. In Section 2, it provides for interpretation, words that are defined. Section 24, subsection 5, defines the word omission, but omission is not in the interpretation section. So that is to go there. 1, 2, 3, 4, the fourth term, existing cumulative addition. Section 2 interpretation, and I'm saying that since that section is a section where terms are defined, having read through the bill at section 24(5), there is the term omission that should properly go there since it's a definition. I'm looking at the fourth term, existing cumulative addition. On the second line of that definition, it says statutes instead of statutes. Now, it is great. We are having a law revision commissioner, and it is the hope and intention that this law revision commissioner would discharge the functions and obligations in a timely manner. And at section 4, subsection B, it says responsible for maintaining the cumulative addition, etc., at any interval which the commissioner considers to be appropriate. I do understand the discretion afforded, but I would like to see that where we are now taking this bold step that we are constantly revising, that at least we set a period for that task to be undertaken as opposed to just leaving it to discretion. And let me say, Madam President, one of the reasons why I appreciate a bill like this is because when you look back for us who interact with the laws and citations, in this millennium, one revision was 2000, the revised edition was 2000. After that, it was 2011, and then after that, published in 2015, and then after that, 2020. So the period in between is too long and far in between, and there are amendments that are made along the way, and it's not being reflected. And so sometimes I remember seeing in court one day a fellow counsel making a valiant effort toward the work that was done, and another counsel tug on the robe to say, hola, they don't change that. And it was a sobering moment to see that an otherwise industrious counsel was defeated because the law had changed, and perhaps questionably industrious, but the law had changed and didn't know, and it was in no repository that it could have been accessed. And so I segue to section 5 that deals with the preparation of an electronic database, and it lists from A to E things that should go in an electronic database. I would like to recommend that what should also go in an electronic database is the white paper for each law and or amendment. Also, references to when the bills, or a link to where the bills were debated, to see what were the considerations that went into it, because sometimes, and I've seen in litigation where dealing with statutory interpretation, the courts have had to go back to look at what was said by the drafters or during debates. And if we're creating a repository, that repository should also have a link to go directly to that to help. And you don't have to do any extensive search. Section 7 sub F that deals with to transfer any provision contained in any law from that law to any other law to which, in the opinion of the Law Revision Commissioner, it more properly belongs. When that is done, that should also form its own space in the database. Section 8, subsection 3, that provides for where an order is made for rectification under 8.1b, that too finds its space in the database. In section 9.1b, is it 9.1b? Yes. That the provisions in 9.1b finds its space in the database, and section 13f which is any appropriation act or any law that, in the opinion of the Law Revision Commissioner, will within 1 year of its having been brought into force have expired or become spent. And that section is saying that the Law Revision Commissioner can omit those acts that would have been spent. And I'm saying for record keeping, it should find its space in a database on its own, since over time these things would be omitted. Right. So these recommendations are only to bolster the bill. I move now, Madam President, to Section 7. I associate myself with Honorable Faber and his observations in that we must be very careful in how a law revision commissioner or any commission is able to alter, change, or so laws that could skirt with the separation of powers, in the fact that we here are the ones responsible to legislate and pass laws. However, I hasten to say that in the same bill, it makes express provision that the Law Revision Commissioner is precluded from making any alteration or amendment in the substance or otherwise affecting the meaning of any law or provision of any law. So that is good. However, what I've found in practice is that what one word might mean to you is different from what one word might mean to me. And in its application or interpretation, those things could seriously affect the provision that is under scrutiny. At 7D Roman 3, where it says the Law Revision Commissioner can transpose words, I put a caveat there that the Law Revision Commissioner could be permitted to do that, but so long as the words fall within the confines of plain and ordinary interpretation of the section, having regard to what the drafters intended. So I think, right, I think in as much as Section 10 is there in the bill to limit the Law Revision Commissioner from changing the substance of a bill, I don't find it cumbersome to ensure that in Section 7 there is a proviso that provides for the Law Revision Commissioner to be guided by the rules and principles of statutory interpretation when doing these things. And it goes without saying that the Law Revision Commissioner would have to be a draftsman of some sort. So not to leave it just to their professional dispatch, but to make express provision for it. Now, in same section 7, it gives it provides a wide list of things a law revision commissioner should do, and I did not indicate that section 7DJ, which is to make such changes in any laws as are required to reconcile seemingly inconsistent enactments. There should be something in the database or some indication for those accessing the database in the future to be alerted that there were things moved or reconciled for inconsistency. What it does not have, and I think we could consider, and I strongly recommend that we consider, that added in the list, which would take it to 7V, is for the Law Revision Commissioner to identify antiquated laws and make recommendations for amendment or repeal. And so that could be an added function, since that person would be the person who would be going through our laws. It should not be limited to what is coming, but also what is behind. And importantly, which would be a 7, Yes, you see me, right? Would be that the Law Revision Commissioner update laws according to unchallenged judicial pronouncements. So where you have provisions in legislation by and large that are challenged in the courts, and the courts make pronouncements declaring them void or unconstitutional or what have you, that the Law Revision Commissioner is tasked to reflect that in those laws, and then that would remove those provisions that are already declared by a court to be so invalid or defined or properly interpreted for its application. And so that would be a good addition to the responsibilities of the Law Revision Commissioner. I'm a bit conflicted on how the rectification of errors in law occur in section 8(1)(b), in that the power to make laws come from the legislature, and at the point of presenting the bill, it would, for all intents and purposes, represent the end of a widespread consultations exercise. And so I'm a bit conflicted in subjecting the rectification of an error to consultation by and large to the public. But what I will say, though, is that where there is a rectification, that it should not be done solely among the Law Revision Commissioner and the Attorney General. We are providing for a Law Revision Commission. We have other instruments in the bill and key stakeholders, even these chambers, just for a check and balance to ensure that when things are being rectified, it has the imprimatur of the National Assembly, and that we're not having a non-legislature change laws just so. The Section 11, the Law Revision Commissioner is permitted to draft a bill to raise the changes of any substance of any law, setting out alterations and amendments, and that is good because it offers parties outside the National Assembly to do work and bring to the attention of the National Assembly, much like the mechanism where you can do private members' bill. But I don't see, and I don't want to take it for granted, that it is understood that a white paper will accompany it. I think it doesn't harm to make express provision that when doing so, it must be accompanied with a white paper. I like Section 12 that says the Law Revision Commissioner can alert any relevant ministry where fees are outdated, fees and fines, so that the relevant ministry could take action to update such fees and fines in certain legislation. For example, I know, and I'm not preempting a discussion or a debate on it, that there are some fees that had to be updated with respect to the very court system, and so that we have somebody who would sit in a dedicated space to do that with a staff. That is welcome. Now in Section 13, Section 13(1)(c), the Law Revision Commissioner has the discretion to omit. C says all preambles or parts of preambles and long titles to laws where such omission can, in the opinion of the Law Revision Commissioner, be conveniently made. I don't think that this should be done at all. There should be no discretion, because preambles, long titles, are aid in statutory interpretation, so omitting them isn't necessarily pardon me? Right, but I'm saying that even though it is there, my view respectfully is that things like that shouldn't happen. The database, right? So if it is, that's what I said, if it's there in the database, then no problem. And I made mention that the database, that Section 5, I believe, that creates the database, that Section 5 needs to be expanded. Right? In terms of creating the space where we authenticate our documents, I see where there is space for us to have a seal, an official seal that will let us know that the law is the official document of the government of Belize, and the bearing of the statement indicating that it was printed by the authority of the government of Belize under Section 16 can go further to incorporate a seal, much like in the court system, when you file documents, there is a court seal, and you are able to see an actual image that tells you it is coming from the court and properly sealed. So that's a consideration. I don't know about Section 17. Why was there a need? Was there the wide use of laws in our court systems that were not authentic? Why are practitioners subject to penalty for producing laws that may not? I don't know. It says there is a offense created by when any person who prints or by electronic means produces or tenders in evidence a copy of any law or a provision of any law which falsely purports to have been printed or produced under the authority of the government of Belize commits an offense and is liable on summary conviction to a fine of $10,000 or to imprisonment for a term of 5 years or to both. That seems a bit excessive, one. And two, if we have a seal for these documents and we know that those are the documents, that seal is the basis by which we can rely on these documents, I don't know. Well, my ignorance to not knowing why shouldn't be the reason, but at least to invite reconsideration for the penalty. I think that is excessive. I do recall, though, in a matter I appeared in, Senator Courtney, you were there, it was like 18 of us counsel in that one matter. And one counsel sought to tender into evidence material that did not meet the standards of admissibility. So maybe, especially for those who would rely on laws to be tendered in evidence, but the penalty is excessive. I don't think it's necessary. If it is, we provide the mechanism by which we can identify that laws are real laws and there is an imprimatur to which we can attach reliance. In section 18(3), that the laws of Belize shall be judicially noticed. We have that provision already in the Evidence Act. I think it's section 6D, Senator Denison. But we do have the Evidence Act that, and I almost want to say I'm sure, but I always leave room for a small margin of error. But we already have provision that jurists are to take judicial notice of laws. And in that same section 6, there is a list of things for which jurists are to take judicial notice. So I don't know the need for having that provision here when it is already in the Evidence Act and it is clearly contemplated, especially in section 17, that laws relied on for the basis of evidence. I want to query whether the copy under section 20 and section 21, 21(2) and 22(1), they all make reference to list of persons or bodies that the Law Revision Commissioner shall provide a copy of revised editions. And my query is, I don't see a space for the law librarian in the law library, although I do see the registrar of the High Court there. And I don't take it for granted that the copy made available to the registrar of the High Court will be applied to the law library, because it could very well be a copy made available to the Registrar of the High Court for the use and benefit of the High Court judges. I'm not saying that they would be selfish and not share, but I'm just querying, and also because currently we do not have a law librarian. I don't know when we'll get one, but we should, especially for matters something like this, right? On the Law Revision Commission, there is also no space for a law librarian, which there should be space for. At section 23 of the bill, request to make subsidiary legislation. 23.2, the recommendation is that there should be a reference, a referral to the AG Ministry, legislative drafting section for that kind of work. Now, in terms of section 24, rectification of omissions from the laws of Belize. The only reason why I say I wouldn't want to have us enjoy a section like that, because it could create the state of affairs where the lower house, maybe not the upper house, but either chambers could get a little bit relaxed on the kind of scrutiny attached to bills, knowing that the Law Revision Commissioner would be there to catch omissions, and that catching an omission and the Law Revision Commissioner being able to address those, especially those that take retroactive effect. Here I say I associate myself with Senator Farber. I don't think omissions, by virtue of it slipping through the lower chamber and the upper chamber and then caught by a Law Revision Commissioner, and there are citizens who would be affected by it, there should be no retroactive effect to those laws. Yeah, we shouldn't, that in principle would be unfair. Now, I move to the part of this bill that, on the one hand, I applaud the government to make available the post of a Law Revision Commissioner with staff, right? It's not certain whether that staff would be public servants, but the staff for the Law Revision Commission are public servants. And we're now finding salaries for a Law Revision Commissioner, an office, the staff, the commission, a chairperson. And I'd like to take this opportunity, since there is a will of the government to do those things and make offices and staff available to respective persons, where it lends to the exercise of our democracy. I'd like to point out here that in 2025, the leader of the opposition has no office of the leader of the opposition that the government supports, create finance for, and the like. And so, it being a constitutional post, not just a post created in a bill, I'd like to invite consideration to the leader of government business, but particularly Senator Courtney. Coy, why do I do that? Apologies. I agree, you know.
Let's stay with the bill. Let's stay with the bill.
It was a well-needed relief, Madam President. Not to say that, there is any measuring. No. But yes, Senator Coe, more importantly, I invite you with your ability, perhaps, to be able to persuade the Prime Minister and tap into whatever mechanisms there are in order to afford the office of the Leader of the Opposition a constitutional position, it being a right thing to do, to make sure that there is such an office and staff. I would like to point out that there is a at section 27 that provides for law revision reports. It says that the Law Revision Commissioner can make yearly reports on any aspect of the Commissioner's work. And while I understand why that is there, but I would recommend deleting the words on any aspect and just leave it to yearly report, so that we don't just get partial reports at a time and there is nothing that would oblige the Law Revision Commissioner to give a full report in any calendar year. And likewise, in section 27 sub 2, the discretionary term may should be changed to shall. Now at section 28(1)(b), this is where I associate myself with Senator Dennison, that, well, to the extent that laws should be public and made available and accessible freely, not that we should be paying any electronic subscription service for such. This is not like a case law database that we should properly pay a subscription for, but this is our laws, our basic laws. No man, you have to pay. They have databases where you pay for access, man. So I'm saying the ability to access the laws, the work done by the Law Revision Commissioner shouldn't be tied to a fee. On the Law Reform Commission, I noticed that the Commission isn't given independence, and it's not given independence because the Attorney General is there to what I call signal and dictate the pace and oversight. Because of that, I query. Within the Attorney General's ministry, there is a legislative drafting section. Why create a Law Revision Commission that will be doing work on the one hand, the same kind of work that the legislative drafting section should be doing? The drafting section is under the AG, but we're also extending that person to be supervising or signaling the pace and oversight of the Commission. Now, if in oversight or maybe a watching way, I have no difficulty, but in determining remuneration and all of these things, I think that should be left properly to the Commission. I note there that there is the creation of the post of a chair, but I don't see that the terms of office for that chair, it's not there. But what is there is that a Law Reform Commissioner has an appointment not exceeding 5 years. It doesn't say that that chair is also treated as a Law Revision Commissioner. And so I ask and query, and it should be clarified, whether there is a term of office for the chairperson, and if so, what is that term of office? Because the Law Reform Commissioner has a term of office, which is identified. What is also silent is the number of law reform commissioners. It doesn't say how many. Law reform commissioner, one law reform commissioner and one chair. No, but I don't. Okay. Because I do see yeah, I'll wait for your response. In section 30, subsection 2, the third line, functions and powers of the Law Reform Commission, that is a marginal note. It needs to be deleted because it goes with section 31(1). I see where in 32 the commission can appoint committees. I don't know if it's necessary to indicate the size of the committees and the kind of persons who should serve in those committees. Section 27, subsection 2 should be consistent. But I am at the end. It's only 38 sections and I am at 34. No, because if you would have been patient, you would have heard that I am saying that section 27 subsection 2 should be consistent with section 34 subsection 2. You see? No, I do it how I want to do it. Maybe if you stood up and said it, you could have done it how you wanted to. And so, with that, Madam President, I would say that the bill is one for ripe consideration by the leader of government business, that we should deal with it during committees to consider some of those recommendations before we think about passing it. But in substance, I support the bill, and it is high time that we have something like this. So I applaud the efforts that has brought it to this stage. I yield.
I recognize Senator Hector Guerra.
Madam President, I just feel obliged to make a contribution to this bill as an attorney. I know the pains that we go through to find amendments, and I know how beneficial it will be to in fact have consolidated laws and laws that are revised from time to time. And of course, for citizens, I know how important it is to be able to access laws. While it's good to have good laws, they're no good if they're not accessible. And so, Madam President, with that said, I want to put on record that I support this bill.
Madam President, first of all, as we indicated and we have all said, the bill is long overdue. Secondly, a law revision commissioner is a specialized skill and a specialized function. The starting premise is clause 10 of the bill. A law revision commissioner has no power to alter or amend the law, the substance of the law. It is an extremely technical profession to go through legislation to find out errors, omissions, mistakes, updating, etc., and to technically correct them without amending or altering the substance of the law. Bearing in mind at all times that if a law revision commissioner presents a revised law, it still has to come to Parliament. So there should be no fear about this, the extensive powers given to a law revision commissioner. Further to that, the law revision commissioner's powers are spelled out in consummate detail. So he has to, or she has to, identify which particular power he or she is exercising when he or she is revising legislation. We all agree that the need to consolidate and to have cumulative supplements on a regular basis. And this is why the Attorney General is bringing forward this legislation at this time with a law revision commissioner, with staff. From time to time, and it's virtually always, some foreigner is appointed as a law revision commissioner who comes in on a part-time basis and does the revision, and that's why there's such a tremendous delay in coming up with our cumulative revised editions. And that is why the hope is that it will be done more regularly and consistently. Insofar as the commission is done, there were two errors, quote-unquote errors. One was the definition omission that can be moved to clause 2, and the typographical error identified by Senator Pitts. Those can be dealt with by the clerk in making the omissions before sending it to the Governor General. With respect to the Law Revision Commission, Section 29, Clause 29, there shall be a Law Reform Commission for the purpose of promoting the reform of the law. The Attorney General shall by instrument appoint a chairperson and such other persons as appear to him to be suitably qualified pursuant to subsection 3 of the Law Reform Commissioners, to be Law Reform Commissioners. So there is a Law Reform Commissioner and a commission. The commission is composed of such persons as the Attorney General determines, satisfies clause 29(3). A person appointed to be a law reform commissioner under subsection 2 shall be a person who holds or has held judicial office, or a person who is an experienced legal practitioner or an experienced teacher of law in a university. And then when you come to where are we? The chairman. Yes, may appoint a chairperson and such other persons. So you have a chair and another person, but that chair is not the Law Reform Commissioner, which was your question. Of what? There is no provision in here, but clearly whatever instrument the Attorney General gives, you're hereby appointed for 1 year, 2 years, or 3 years. Not exceeding 5 years. That's for the Law Reform Commissioner. But it doesn't say for the chair, that's what I'm pointing out. I understand. And I'm saying that the Attorney General will appoint that person by an instrument which will have his or her term of office.
We're hazarding and guess that it is tied to the 5-year term like the commissioner.
Clause 32 is important because Senator Faber raised the question about consultation. There is no need for consultation with law revision.
It's just the law.
Yes, the law is there. It's just revising the law. Insofar as the law reform is concerned, there has to be consultation. And if you look at 32, it says in performing any of its functions under 31, the Commission may from time to time consult any person who has specialized knowledge in any branch of the law or any technical expertise in any particular field. Appoint committees to provide advice and information and to consider and report on any matter referred to the Commission. In appointing persons as members of a committee under subsection 1B, the Commission shall not restrict consideration to members of the legal profession. The point is, unlike law revision, which is revising an existing law, law reform is people making, if you look at 31(2)(a), the Law Reform Commission shall have the following powers: to receive and consider any suggestion or formal proposals for reform of the law which may be made to the Commission. That's from the general public. NGOs, persons, etc., come forward and say, we want law reform in family law, we want it in church law, whatever. The Commission appoints committees to look at it, and those committees don't have to be confined to lawyers. They are experts and persons outside of the legal profession. A report is prepared. The reason why the Attorney General has to be central to the law reform process is because when the law is prepared, the only way that law can reach the National Assembly is by it going to Cabinet, Cabinet approving it, and then it is tabled in the National Assembly. So he has to be the engine that brings it from the result of the reform, bring it to the Attorney General. The Attorney General takes it to Cabinet and brings it in here. Sorry. Madam President, let me just close by saying this.
So we can't bring a private bill?
Oh, of course.
It be like that?
It can be. Well, I mean, anyway. Madam President, Senator Pitts went into great detail with comments, suggestions, etc. Quite frankly, I think this is one where Mr. Price would tell us, don't let the best be the enemy of the good. The bill is good. It is not perfect, but I really think that we should pass the legislation and let's get it implemented, enacted, and get this process moving. To the extent that there is any need for any further amendments or changes in the future, I think we should adopt it then. But I do thank her in all sincerity for all her contribution on the bill, but I really ask senators to approve it and support it. So I ask that the question be put.
Honorable members, the question is that the bill for an act to repeal and replace the Law Revision Act, Chapter 3 of the Substantive Laws of Belize, Revised Edition 2020, to modernize the system of revising, consolidating, and editing the laws of Belize, to establish an official law reform commission to allow for the laws of Belize to be reviewed and reformed on a systematic basis, and to provide for matters connected therewith or incidental thereto be read a second time. All those in favor kindly say aye. Those against kindly say no. The ayes have it.
Bill for an act to repeal and replace the Law Revision Act, Chapter 3 of the Substantive Laws of Belize, Revised Edition 2020. Committee of the Whole, Senate on Motions and Bills.
Honorable members, in accordance with Standing Order 68A, the Senate will now resolve itself into the Constitution and Foreign Affairs Committee, a committee of the whole Senate, to consider the motions referred to it, and thereafter, in accordance with Standing Order 54, the committee of the whole Senate to consider the bills that were read a second time. Honorable members, I will now take the chair as the chairperson of the Constitution and Foreign Affairs Committee, and then as the chairperson of the Committee of the Whole Senate. Honorable members,